those I would argue are admissible under 8033 as
Sorry,
evidence of
did you
plan.
take Caitlyn Naffziger's testimony?
Through Mr. Duren's statement testimony, elicit statements of Caitlyn Naffziger in Mr. Duren's testimony. They're admissible under 8033 as an existing plan, but in the alternative, they're also admissible as non-hearsay for the effect on Mr. Duren. The statements themselves, not how Mr. Duren responded to those statements, although that's also admissible, but the statements themselves are non-hearsay. Rule 801C, hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and that a party offers in evidence to prove the truth of the matter asserted in the statement. And quoting from State versus Plantamuro, 171, New Hampshire 253, quote, whether a statement is hearsay depends upon the purpose for which it is offered. If a statement is not offered to prove its truth, but is offered for some other reason, it is not hearsay, end quote. And Plantamuro is citing State versus Reinholz, 169, New Hampshire at 28. Examples of statements that are not hearsay are statements offered to prove circumstantially the state of mind of the declarant. So that would be an admissible purpose here. Statements offered to prove their effect on the listener, again an admissible purpose here. Or statements offered to prove only that they were made, why a witness pursued a course of action, or why a witness had a certain reaction. Words of legal significance. And so the statements that Caitlyn Naffziger made to Dustin Duren the day of the incident are admissible both under 8033 and as non-hearsay for the purposes including proving circumstantially the state of mind of the declarant and proving the effect on the listener. I'll also note a couple other cases, although I won't go into extensive detail. State versus Gabusi, 149 New Hampshire 327. That's a 2003 case. At a bench conference, the defendant's counsel explained that the statement would be offered not to prove the truth, but to show the defendant's belief. And the Supreme Court found that the trial court improperly excluded those statements. And in State versus McPherson, 127 New Hampshire 826, a 1986 case, the Supreme Court found that the trial court committed reversible error in excluding statements that were sought to be introduced not for their truth, but for the state of mind of the defendant. And so I want to just be clear that, that the argument that statements offered not for their truth are hearsay is not one that is legally correct, just to kind of preempt any need for extensive bench conferences while the jury is here.
Understood. Attorney Reed.
Your Honor, the state's well aware of what hearsay is and is not. We appreciate the lesson from defense counsel this morning. We'll object as statements become necessary to have objections.
Okay, specifically going back to Friday, Attorney Kettles, is there any specific issue that you want to, understanding the argument generally speaking, is there anything, if we parse this going forward as opposed to going backward, is there any specific issue going backward?
Going backward, Judge, I think that the court erred in not allowing Mr. Duren to testify about the specific texts that he received from Ms. Naffziger for their impact on him. What the texts themselves said. The court allowed him to testify that he received texts and that they had an impact on him, but the language of the text themselves should have been admitted.
Okay, Attorney Duren.
Your Honor, the language of the text is hearsay. Defense counsel was given every opportunity to discuss the defendant's impression of those texts and what it meant. And the testimony is what it is from last week.
So this is the same issue we're having on Friday. If they're offered not for their truth, but for the impact on Mr. Duren, they're non-hearsay. That's what the rules of evidence say. That's what the case law says.
With respect to texts, one of the things that I discussed during the bench conferences was there a specific text message that, out of many, that defendant wanted to introduce? And I know there was a large portion or a large volume of text messages. I note there wasn't any specific motion in limine relative to the voluminous text messages that are likely to exist. I haven't seen them. They weren't provided to me, not that they had to be provided to me, But again, I would note that there wasn't a specific motion in limine relative to text messages so that they can be appropriately sanitized and addressed, which is typically what happens when there's a slew of text messages in any case. In modern communication habits, modern technology, modern society, communication, there's a lot of text messages that go on. And my experience is typically if those are going to be highly probative on any issue, they will specifically be brought to the court's attention for purposes of editing and sanitizing what is usually quite a lot of hearsay and quite a lot of issues that come up, whether it's in texts or emails, quite frankly. And I note there wasn't a specific motion in limine relative to text messages. And again, I think that the state of the evidence on Friday was that I was allowing defendant to testify about the effect of the text messages on him. So again, is there a specific issue within the scope of that, within the scope of my prior rulings? Is there something specific that defense counsel, one specific text or comment that the defendant is asking me to reconsider at this point in time?
Yes, Judge. As I mentioned on Friday, the specific text that we were seeking to admit, and I'm not seeking to have this entire packet admitted to the jury. Mr.
Okay.
Duren can testify what the texts he received are, and that would be sufficient. So the ones that I think are particularly at issue are the text messages where Mr. Duren asks, "So were you planning to stay with her, or are you staying at our house?" And Ms. Naffziger responds, "I spent most of my childhood running out the back door barefoot and hiding in the woods. I am not going to trap myself in an unfamiliar place where I am uncomfortable for several consecutive days. No one benefits from someone being debilitatingly anxious." And Mr. Duren responds, "Okay." The second step.
So let's stop right there. So are you seeking to admit that one?
Yes, I'd like to have Mr. Duren testify as to that exchange.
Okay. Attorney Duren.
Your Honor, we understand that defense counsel is standing in front of this court saying that we're not trying to admit those for the truth. Mr. Duren was able to testify, however, that based on that text message communication, he didn't believe that Caitlyn was going to be staying at his house. There are statements inside of that. You want to talk about what her anxiety is, what the basis of her anxiety is, why she would feel trapped. We're not able to get into the relationship with Mr. Duren in terms of Ms. Naffziger's feelings, but that sure brings some of them up. Your Honor, the exact content of the text message is exactly what defense counsel is trying to get into. They're trying to put that in. Otherwise, the impression that Mr. Duren has from it is sufficient. She wasn't going to stay there, and he has testified to that over the last 3.5 hours.
As to that specific text message, motion to reconsider as to that specific message denied. Next one.
Yes, Judge, and again, this is a set that I reviewed specifically with the court on Friday.
Yep.
Is it just you and Brenda? Is the question from Mr. Duren. The response is, "She'll drop me and Valen. She has to get back to work more," from Ms. Naffziger. And then Mr. Duren says, "Is she picking you back up then?" And Judge, I think we have a fundamental issue here, which is that the content itself is admissible as non-hearsay. Not just the response of like, this is how the text made me feel, but that what the text says is admissible under Gabusi, McPherson, under Plantamuro, and under Rule 801C2. And so it's not just the response, because the response is meaningless without understanding what causes the effect on Mr. Duren.
Okay, with respect to that one, Attorney Duren.
Your Honor, if that's defense counsel's argument, then they're arguing that the response comes in for the truth. They're arguing that the response itself and the content of it is what the jury should consider.
The effect on Mr.
But
Duren.
what the effect is on Mr. Duren, he has testified to. And the only effect, it's not like it affects him in any way other than based on that text message, he knows that Brenda isn't going to be at the restaurant. He doesn't know what's going to happen at the end. He knows she's dropping Caitlyn off. The content of the text message is what defense counsel is trying to get in here. They're attempting to be able to put that conversation in front of this jury and put it in as truth and fact, which is fine, but that makes it hearsay, and there are statements inside of these text messages that are not admissible. And as such, Mr. Duren has, and again, he testified for 3 hours on Friday about the background. We haven't even gotten to the crime that this jury is here to consider, and defense counsel now wants to get back into something that he's already testified to, which is that he knew when he went to the restaurant that Caitlyn didn't have a ride, that she was dropped off and left there. It's been testified to. It's very clear this jury already has it. And the state relies on its arguments that were made at the bench and relies on the ruling of the court.
And Judge, as I stated on Friday afternoon at the bench, for statements that are not admitted for their truth, the defense would not object to a limiting instruction, saying these are being admitted not for their truth, but for the effect on Mr. Duren.
And with respect to the statements that you've just indicated relative to that text message, number one, I fail to see the distinction between how they're not being offered for their truth. In other words, I understand the effect upon Mr. Duren. He's testifying about the effect that it's receiving upon him. He's testifying about the scope of his knowledge as it relates to what he's thinking, as it relates to his objective state of mind. In other words, what he's going to do next. And I think he's also testified relative to his subjective state of mind, the effect that it has upon him. And I fail to see the evidentiary value when it seems to me that they are being offered for their truth as it relates to the effect upon what's going to happen during the day compared to the effect that it has upon him as a listener. So it seems to me that they are being offered for their truth. I understand that you're arguing that they're not being offered for their truth, but the truth of the statement is the effect that it has upon the listener under the circumstances.
Judge, let me give an example. If I am in a car accident, if my car is hit by a red car, and I call the police and I say, I just got in a car accident, I just got hit by a blue car, and the police then go and stop a blue car that they feel was involved in the offense.
Mhm.
My statement, I just got hit by a blue car, is admissible, the statement itself, for its effect on the listener, even though it's not true. So regardless of the truth of the statement itself had an effect on the listener, and that's the reason why it's being admitted. So whether or not, right, this statement would be admissible under its theory, whether Brenda had gone with him or not, or her or not, whether or not it was true. It's not about the truth of the statement. The fact that it happens to be correct is irrelevant under this theory of admissibility. It is the fact that that had an effect on Mr. Duren, and he did something, he felt something in response. The same way the police would do something in response to my statement, I got hit by a blue car.
Understood.
And just to be clear, Your Honor, my notes from the testimony indicates that the defendant stated that based on the text conversation, he knew that Brenda was going to drop Caitlyn off. That confused him because it was a long drive. So all of this is already there, and none of it is relevant to whether he murdered Ms. Naffziger or acted in self-defense.
Okay, with respect to that one, again, right now we're going backwards. With respect to backwards, I will deny any motion reconsideration relative to that specific statement, again, going backwards. Next statement, Attorney Kettles.
Judge, the rest I think is an issue that'll come up
Prospective?
prospectively.
Prospective, okay. And understood relative to prospective as well. But are you satisfied with the argument retrospective?
Yes, Judge.
Okay, all right. Anything further on that?
No, Your Honor.
Okay. Okay, anything further at this point, Attorney Duren?
No, Your Honor.
Okay. All right. Ready for jury counsel?
Yes, I'll just ask Mr. Duren to retake the stand.
Okay, please.
session. The Honorable Jonathan F. Gazelle presiding.
Hey, good morning, thank you. Please be seated. Okay, good morning, members of the jury. Thank you for your service. Thank you for your punctuality. As I've asked you in the past, I'll ask you again, because there is a media presence with respect to this particular proceeding. I have instructed you to not avoid any exposure relative to any media coverage, but I would ask you now if you have received any media coverage, as you've received any information or have reviewed anything relative to any media coverage, even if it was inadvertent, I would ask that you please raise your hand and indicate so that we can address it. Okay, let the record reflect that none of the jurors have raised their hands. Thank you very much for adhering to my instructions, following my instructions. And with that, we'll proceed. Attorney Kettles? And Mr. Duren, you're still under oath, sir. Yes.
Dustin, where we left off yesterday, you had just returned from the library and eaten lunch. Can you tell me what happened after lunch?
So this was at the house. Caitlyn, Elowen, and Valen were all playing in the girls' room. And at that point, I'm just kind of working on things, like kind of getting stuff set up for the weekend and the following week. And then every so often, I would go to the room just to ask, hey, what's going on? Is Brenda picking you up here? Are we meeting her somewhere? Just what's the plan? What is going on?
What did Caitlyn say in response?
She was not responding. She was completely ignoring me. Just kept playing with the girls. So about like every 15, maybe it was a half an hour, maybe every 15 minutes, a half an hour, I would come back and ask again, hey, what's going on? What is the plan? And she just kept ignoring me.
What did you think when she kept ignoring you?
So I don't know what's going on. So with backing up to what was happening prior to, again, she was saying that she didn't want to stay at the house, which is fine. But then all of a sudden Brenda isn't coming with us to the restaurant. She's not staying there. She wanted to come back to the house all of a sudden. I'm confused about what is going on. There's a lot going through my head. And one of the things that's in the back of my head, which is why I'm bringing up these stories in the first place, is that the last time she was ignoring me and not telling me what was going on was when she stole Valen out of Nevada.
At some point, did you tell Caitlyn that she couldn't stay in your apartment anymore?
Yes. So this is when I'm continually asking her about what's going on. I'm saying, hey, I said that you could stay the night, but you can't stay longer. So what is the plan? You can't stay here. What is the plan? Like, if I need to drive you all the way back to Hampton, fine, but I need to know what is going on.
What was the next thing that she did besides just ignoring you and playing with the girls?
So eventually, at this point, it was getting dark. And eventually, as I'm saying this, she finally gets up. She still hasn't said anything, but she finally gets up and goes to the couch in the living room. And she's on her phone. I don't know what she's doing. It looks like she's texting. So I'm thinking, okay, progress is being made. Like, okay, I'm assuming she's texting Brenda. Okay, she's figuring something out. Good, we're making progress here.
Did you ask her again what the plan was?
So after, again, I don't know how long this would have been, maybe 10 or 15 minutes. But again, she wasn't saying anything. So I'm asking again, are you talking with Brenda? Like, what's going on? What's the plan? and she's still not saying anything. So at this point, like, I'm obviously pretty frustrated. At this point, I'm just saying, okay, you know what? You're not responding. We're clearly not getting anywhere here. So then I'm making the decision that then I'll drive you all the way back to Hampton. I'll drive you the 3 hours or whatever it is, all the way back there. But we need to leave now. You can't be here any longer. We need to leave now.
And what was going through your head at this point that you're telling her we need to leave now?
So again, I don't know what's going on. And again, in the back of my head, I'm thinking, oh, the last time that she wasn't communicating with me was in Nevada with Valen. And I don't know who she's texting. She's sitting on her phone. I don't know who she's texting. If, like, did people come to New Hampshire with her? I don't know. Was she texting other people to, like, come to the house and that's why she didn't want to leave? Like, I didn't know what was going on. I wanted her out of the house. I did not know the situation. I did not know what was going on, but something was happening. Something was seriously wrong. I wanted to get out of the house.
And what did you do next?
So at this point, this is when I get Valen and I start putting her in the car seat. And so I'm putting her in the car seat in front of the kitchen, sort of at the doorway in front of the kitchen, also in front of the doorway to the bathroom, and it's in the hallway that leads outside to the garage. So I'm putting her in the car seat. At this point, Elowen she's still kind of playing in the room and going back and forth and seeing what we're doing. So at this point, she's out like, okay, we're going somewhere. So she comes out and she's standing behind me in the kitchen. And this is when Caitlyn gets up from the couch, grabs Elowen, and then takes her back to the couch.
When she takes her back to the couch, how are the two of them seated?
So, yeah, after I finish buckling in Valen, then I go into the living room, and I see, so Elowen's sort of straddling Caitlyn's right leg. She's facing me, so like Elowen's legs are on the outside of Caitlin's right leg. And then she's facing out towards me, and at this point, just one arm, Caitlyn has one arm around Elowen, like around her chest.
And what did you do when you saw Caitlyn holding Elowen from behind?
So I just started saying, hey, what are you doing? We need to go. And at this point, this is really to where the first time she said anything in which she just said, no, I'm not leaving.
What did you do when she said, no, I'm not leaving?
So again, I start saying, no, we need to leave. We need to go. And at this point, I go up and I try to grab Elowen. And what ends up happening is she pulls back on Elowen and sort of yanks her out of my reach, like away from me. So she yanks her back, and I immediately step back, going, whoa, 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 what is going on? What are you doing? Let Elowen go.
And so Caitlyn yanks Elowen back. How is she holding Elowen at this point?
So at this point, just again this was with, I guess probably one arm at this point, but holding her across the chest and then like yanking her backwards.
And you said you let go. Why did you let go?
Because I couldn't hurt Elowen. I didn't want her to be hurt.
And what did you do next after you let go?
So I'm really trying to ask, like, what is going on now? Like something is seriously wrong. What is going on? And this is where she first starts really talking, and where now she's making these demands for just a substantial amount of money that there's no way that I could pay her. And I'm telling her this, like, I can't get you this kind of money. Like, I don't have this kind of money. I'm paying you what I can. I'm sending you what I can. I can't pay this. And then at this point, this is where she's saying, or now threatening, that then, oh, if I can't pay her, then she's going to say that I kidnapped Elowen from Minnesota without her permission, and that she was gonna call the cops and have me arrested, and that then I would never see the kids again.
And just to be clear, had you kidnapped Elowen from Minnesota without Caitlyn's permission?
No.
And what are you thinking at this point that you're hearing these threats?
So at this point, I think the best way to describe this, I think, is in like a Marine Corps color code system. So it's like a situational awareness, like an internal radar system, but to where just naturally, just a normal person would just be in white. Like their radar is off. They're not, like you're walking into a restaurant and you're not concerned with, like you're not thinking about threats. You're thinking about like what's there to eat. But I think combat vets, probably police officers, I think can say the same thing, that they're probably going into a restaurant and they're just kind of aware of maybe suspicious people or suspicious things that are around, or they want to sit in a corner booth or with their backs against the wall so that they can visually see things. So that's just a natural yellow, like your radar's on a natural yellow.
And what is your radar on most of the time?
Yellow. So I'm constantly on yellow.
And at this point, as Caitlyn is making these threats, what does your internal radar do?
So now at this point, I'm in orange,
What
which
orange?
is, so I'm now seeing a potential threat. I'm seeing my child being restrained to where I can't get to her. I'm thinking of all the suspicious stuff that has been happening about how there's some sort of plan going on, but I don't know about what's happening. And now and with these threats now and her not leaving, like something is seriously wrong, something is seriously happening. And with her now holding Elowen hostage and making these demands, my radar's on, it's on orange, I'm seeing a potential threat, and now I'm observing what else is going on. So at this point, this is where I'm thinking, okay, weapons. Okay, my desk, or my gun is on my desk next to the couch. I'm thinking of the knives that are behind me. I'm thinking of the doorways, like the front door is behind me. I'm thinking, is it locked? I think it is. The front door, or the door that's in front of me is the back door towards the garage. I'm thinking, okay, that door I think is unlocked. I'm conscious of, oh, she's been sitting on her phone. Is she texting someone? Are people coming to the house? Because I don't know what's going on. She's on her phone. Is people coming to the house, and that's why she doesn't want to leave? So now I'm thinking, I'm conscious of like the windows. Are there lights shining in the windows? Like, is someone pulling up? Are there car doors shutting? Are there people talking outside? I'm just listening for all this stuff. It's just this heightened sense, the situational awareness, where I'm just in a heightened state trying to figure out just everything that's going on.
And what do you do while you're in this heightened state? What do you ask Caitlyn?
So I'm now again, I'm just trying to say, hey, just let Elowen go. Like really just let Elowen go. And trying to figure out like what is going on. And again, she's just talking about these, like how she wants money. And, oh, if I can't pay her this money, then I need to sell my car and give her the money from my car. And again, I'm trying to explain, like, I can't do this. I'm sending her what I can't send her this money. And then she just continually threats that, okay, then you're never going to see the girls again.
She tells you you're never going to see the girls again?
Yes.
And what was she doing while she was telling you she's going to take your girls and you'll never see them again?
She's holding Elowen hostage in front of me, using her as leverage to try to get what she wanted.
What are your daughters doing at this point?
So Elowen's crying, and this is why I'm saying, like, Elowen, like, she's smart. She knows when something wrong is happening. So she's crying already. Vaylin's crying. She's in the hallway, and I can't specifically see her. Like at this point too, I can't take my eyes off of Elwyn or Caitlyn. And like, I don't even want to go into the kitchen to check on Vaylin. Like, I can't just take my eyes off of them. This potential threat, I can't go over there and check on Vaylin. So that's stressing me out too, of Vaylin crying in the hallway. It just, yeah, it's just adding to the stress.
So what do you do?
So at this point, I'm saying again, just let Elwyn go, and I try to grab Elwyn again. And at this point, again, now I'm trying harder to get her, so now Caitlyn is trying harder to keep her away from me. So again, she's pulling Elwyn in tight and yanking her away from me. And so again, I back up because I don't want Elwyn to get hurt in this situation.
And what do you do after the second time you try unsuccessfully to get Elwyn out of this situation?
So at this point, and this is when I'm talking about the point that I'm yelling. At this point, I am yelling. I'm yelling like, what the hell do you want? I'm just screaming like, what the hell do you want? What is going on? Like, let Elwyn go. And she's refusing to do it. She's just saying no, like, I need to pay her. And again, if I wasn't doing that, then I was never going to see the girls again.
And what was Caitlyn doing? You've said what she was saying, but how is she holding Elwyn at this point?
So she's still got her at this point, still one arm, like maybe, maybe the other arm is like on her hand or something. Like, this isn't full bear hug. This is like one arm around her chest, but yes.
And what is going through your mind?
So I'm trying to figure out what to do. Just with everything that's going on, I'm trying to figure out, like, how can I get Elwyn out of this situation? And I'm just pleading, like, please just let Elwyn go. Just please let her go. And at this point, she's not responding. And to her phone, I'm noticing to her phone, because her phone was sitting down on the couch at this point, but it was on the couch and it was flashing, like white flashes, like she's getting texts or something like that. So again, I'm like, I don't know what's going on. All I'm thinking of is I need to get Elwyn out of this situation, just getting out of here.
And you had said earlier that what was going through your mind was that Caitlyn had kidnapped Vaylin before.
Yes.
Overall,
What's different this time?
I mean, the big difference is because she's literally holding Elwyn hostage in front of me. She's using her as leverage to try and get what she wants.
And what are you saying at this point?
Again, I'm just pleading for her to just let Elwyn go. And yeah, she's just not, at this point, she's just not responding to me anymore.
What do you do next?
So this is when I try to make this final attempt to get Elwyn. So my thought is, okay, I'll try to grab like Caitlyn's wrist that's across Elwyn. I'll try to grab her wrist. I'll try to get behind Elwyn's back to pull her away, to like simultaneously pull her arm and pull her away. So when I attempt this, when I try to do this, then that's when Caitlyn goes full bear hug. She's then squeezing Elwyn harder. She's yanking her away, like twisting her body and yanking her away from me. And two, she's putting her right foot up on the table. So her knee is up, and So Elowen, being straddled on her leg, she puts her knee up, braces it on the table, and is also using her leg to pull Elowen back away from me. And just the big thing that happened here is Elowen screaming, Elowen yelling. And that was the point to where, again, I let go after Elowen's scream. And I'm locking eyes with Elowen, and she's crying. She just let out this scream, and this is where, when I'm talking about the line was crossed, this is what I'm talking about. I'm talking about Elowen now physically being hurt in front of me. And that was the line.
And what's going through your mind at this point when you've locked eyes with Elowen and you can see that she's been hurt?
So then this is probably the best way to describe this, again, is through this system, this color system, to where now I'm going from orange to red, to where I see an immediate danger. I'm seeing an immediate threat to Elowen, and I have to take action immediately to save Elowen. And that's really what's going through my head, the single thing of, I have to get Elowen out of this situation immediately.
What do you do?
So this is where I'm talking about, to where I say it's like, it was like muscle memory. It was like training coming out, to where I didn't have to think about what was happening. It was like I was trained for this, and this is what I'm supposed to do. But I take then, and this is also, again, this is, like I said, it was really, really fast. The entire thing probably took like 3 to 5 seconds max. I take the 2 steps over, grab the gun. As I'm taking probably the 3 steps back over, I'm chambering around into the gun. I grab Elowen by the shirt collar, the front of her shirt collar. I pull her forward, not to me. I pull her forward to get some sort of distance between her and Caitlyn. Pull her forward, and then fire.
Is Elowen still in Caitlyn's arms when you shoot?
Yes.
What happens after you fire?
So immediately after I shoot, so I'm holding Elowen by the collar. She's, again, Caitlyn is still bear hugging Elowen at this point, but the moment I shoot, that's when Caitlyn releases. I pull Elowen fully into me, and I immediately run out the door and run to my car.
After you run to your car, what do you do?
So once I'm in the car, this is when, again, the very first thing I'm thinking of is I need to make sure that Elowen is okay. So we sit down in the car, and I'm just checking her over, like physically, to make sure that there is nothing wrong with her, that there's no physical injuries wrong with her. I'm like checking through her hair to make sure that there's just nothing wrong. And there wasn't, but all she's complaining about is she's covering her ears and saying loud, loud. But she's still responding to me. I know she can still hear me, but she's just complaining that it was loud. And as I'm checking her over, I'm not seeing anything physically wrong with her. There's also nothing on her. So I'm making sure that she was okay, and she was physically okay.
Once you make sure that Elowen is physically okay, what happens next?
So at this point, this is when I said this, to where this is when I realized what had happened, to where, like, consciously I'm realizing this wasn't just someone that I shot. This was Caitlyn. This was someone that I cared about, who was important to me and my family and my kids. This wasn't just some random person. And I immediately felt horrible. And I didn't understand what was going on. Like, why was this happening? What just happened? Why was this happening? I didn't understand it. So at this point, I'm just trying to figure out what am I supposed to do? I didn't know what I was supposed to do at this point. I'm not thinking like, yeah, I'm not thinking, oh, I'm justified actually because of XYZ. I'm thinking, no, I just shot someone that is not just a random person. This was Caitlyn. I didn't know. Anyway, I'm trying to figure out what to do. And this is again to when just sort of basic instinct is coming out, to where I'm thinking, well, I need to make sure that my kids are okay. So I'm thinking, okay, Elowen is physically okay, but I need to make sure that she's mentally okay too. I need to, one, because again, I don't know who she was texting, if people were coming to the house. I didn't know what was going on. I wanted to get out of the area, out of the immediate area first. And I wanted to spend time with the girls to make sure that they were mentally okay. So at this point, this is where I am. I'm literally running into the house, just grabbing necessities. I'm like, okay, I'm just grabbing clothes. I'm grabbing blanket. I'm grabbing a pillow. I'm like grabbing what I like, food, water. I'm just grabbing necessities to just bring back to the car. This all probably took maybe 5 minutes total as I'm just running in the house and just grabbing things. I know, yeah, I grabbed my computer and my hard drive. I guess it was because, okay, my computer is my life outside of my kids. Like, this is where I do all my work. Like, my hard drive, literally the only thing that's on my hard drive is all backups of my work. So I guess I'm just thinking like, oh, well, this is a necessity. I just have to grab it. So I just grab it. And as I put all this stuff in the car, then immediately take off after that probably took like 5 minutes.
Did you turn out the lights and deadbolt the door?
I mean, I guess. I don't consciously remember doing it, but I guess it makes sense because that's just what I would normally do. Like, hey, I'm leaving the house, I'm turning off the lights, I'm locking the door. I mean, deadbolting the door, I don't even think I had the key to the actual doorknob. I think the only key I had was for the deadbolt, so I guess it was just something natural that I would do as I'm leaving the house, is just turn off the lights and lock the door.
And so, have you also put Valen in the car at this point?
Yes, Valen's in the car as well, yes. If it's not obvious, she was the very first thing I went and got from the house, yes.
And what did you do next once you had packed up the car?
So at this point, I immediately got out of the immediate area. And Elowen and Valen, they both fell asleep pretty much immediately once I started driving. So I just kept going. I just kept driving. Eventually, I got to Concord, and to where they're both awake at this point. And I wanted to, again, make sure that they were mentally okay. So I park, I think this was at like a CVS or a Walgreens or something. I park in a parking lot. And I sit down with them, I'm talking with them, I'm just making sure they're okay. I'm not talking about what just happened, I'm just asking if things are okay. And talking to Ellen specifically, I knew Valen was her same old happy self, so I wasn't worried about Valen, and she wasn't even in the room when this was going on. But Elowen, I'm talking to Elowen, and she seemed good. She kept saying, like, I'm okay, Dad, I'm okay. And so at this point, now I'm thinking too, okay, well, I haven't received any texts from anyone. I don't know. Again, I don't know if people were coming to the house. I haven't heard anything. I don't know what's going on. I don't even know if anyone knew what had happened. So I'm thinking I have to tell somebody. So at this point, I do three things. First I make a video just showing that we're all okay, that Elowen and Valen specifically, that they're happy and that they're okay. So I just record a video. I'm telling Elowen that I love her, and she's saying, I love you too, Dad, and I'm hugging her. And then Valen, I'm saying I love Valen, and Elowen says, oh, I love you too, Valen, and we're just hugging and just making a recording showing that we're okay and we're happy, and that we're okay. And then I send that to my parents. The second thing I do, because I was already thinking this before I had called my parents, but I was thinking again, I didn't know what to do. I didn't know what was the right thing to do in this moment. And I didn't understand what was even happening at this point. What had happened, like the why, the what, but anyways, so I'm thinking, okay, I still want to spend more time with the girls. I want to, again, just make sure that specifically Elowen is mentally okay. So I'm going on Google Maps, and I'm sort of planning a route west because I knew I was going to shut my phone off. So I'm planning a route southwest through New York, and I'm writing it down on a Post-it note, which the Post-it note that was still in the car, so you could literally see the route that I took. But I write it down on the Post-it note, and then 3, I call my parents.
Who do you speak to specifically?
So specifically, I call my mom, and I don't tell her anything specifically what happened. I just tell her that I shot Caitlyn, that the girls were okay, that I was gonna go dark for a little bit, as in turn my phone off, specifically because I didn't want anyone to find us at that point. I wasn't trusting anyone else to make sure that my girls were okay in that moment. Like, I was the only one that could make sure that my girls were okay. So I didn't want to be found at that moment. So anyways, I'm telling my mom this, and I'm telling her, hey, you also need to call the cops to make sure that they know what happened. And that was the extent of the conversation. I didn't tell her anything more than that.
Which of your parents did you think would call the cops?
I mean, I guess I would assumed it would be my dad, especially as a retired deputy. I assumed he would be the one to do it.
What did you do after you talked to your mom?
So at this point, this is where I did turn off my phone. And again, I just started driving southwest. So I drove kind of throughout the night, and made it somewhere into New York. to where it was specifically at a Love's gas station. And again, you could figure out where exactly I was from the Post-it note that I wrote down, like the directions on the Post-it note. You could find this gas station. But anyways, so I stopped there. I parked up. There was a gate or a fence in front of me, pulled up to that, and that was overlooking the freeway. Just pulled up to that, and then just the girls and I slept in the back seat and just slept for the night.
What did you do when you woke up?
So we woke up, everyone, again, Ellen seemed good. She just seemed like her happy self. I mean, we go into the gas station. I mean, we're using the restroom there. Where her interactions with Valen were all good, and everything seemed like she was acting normal, completely fine. We had breakfast there, and this is really at the point to where, because one of the things I was thinking of doing was to drive all the way back to Minnesota to get my kids to my parents, because no one knows my kids better than my parents. No one has been more involved with my kids than my parents. So they were my first thought of who could take care of them. So I was thinking of, okay, well, maybe I'll drive all the way back to Minnesota. But again, that seemed like a bad idea because just with the two girls, I mean, specifically with Valen too, being so young, it just didn't seem like a good idea. But to get back to it, Ellen specifically, again, she just seemed fine. She kept saying that, yeah, she's okay. And her interaction specifically with Valen, her interaction specifically with me, she seemed like her same old self. And this is really at the point to where I was thinking, okay, I'm not going to drive all the way back to Minnesota. I should probably turn myself in at some police station. And why I was thinking Concord specifically was because that's where I had originally called, and that was the last place my phone was, or where my phone was on. So that's just why I was thinking Concord. But anyways, so I started driving back. Took the same path back that I had originally driven. And then started thinking that, okay, now I want to get brunch with the girls. And it probably is fair to say that, yeah, I was probably delaying things. And that's probably fair to say that I probably was just delaying things, but I just thought, okay, I want to have brunch with them.
Before what?
Before turning myself in. So.
Did you have brunch with them before you turned yourself in?
No.
What happened?
So, as I'm driving through Keene, so I just entered New Hampshire, and I'm driving through Keene, and I'm looking at restaurants, and as I said before, I see the Applebee's. I'm not looking at anyone else. By the way, I never even knew that there was an Amber Alert. I didn't even think about that would happen. So I didn't know that this was anything other than just police were trying to find me. I didn't think about anything. So anyways, I'm not like looking around at other people. I'm just looking at the Applebee's. And I've never been to Keene before. I've not been to this Applebee's. So I'm just trying to figure out like how do I get into the Applebee's? So I'm like taking a left, and then I'm like, okay, well now there's a median and I can't turn left into the Applebee's. So I'm like going around this roundabout and going back right, and I'm like taking a right, and I guess I turned into the convenient MD, I guess, but then obviously that's not the Applebee's. So I'm pulling in farther through it. And I pull up literally right in front of the door to the Applebee's.
And then what happens?
So I'm just looking at the hours sign. I'm trying to see the hours, and it was closed. But I'm just trying to look out my window, just trying to see the hours. And that's when I noticed the police officer behind me. And I honestly, I can't remember if he had lights on. I don't remember that. He didn't have a siren on.
What did you do when you noticed the police officer?
So at this point, I'm like, okay, well, now even if he's just pulling me over just for some random thing, they're probably going to look up my plate and then see something like that this call was made or whatever. So at this point, I pull forward into a parking spot, and then I'm leaning back. Ellen and Valen were still asleep at this time. I'm leaning back, and again, I'm thinking like, man, I really just want to hug them. And so I'm leaning back. I'm unbuckling Valen, reaching back, unbuckling her seat, and I'm trying to wake them both up. Like, Ellen, Valen, hey, wake up, wake up. And they're both starting to wake up. But at this point, this is when I start hearing people outside, like the officers outside, yelling at me to whatever, get my hands on the steering wheel or put them on the window. So at this point, I didn't want to do anything further. Like, I'm gonna follow their commands. I didn't want anything to happen to Ellen and Valen. I want to make sure that everything was good, so I was fully cooperating.
And what did you tell them?
So immediately I'm just yelling like, hey, there's kids in the car, just making sure that they know there's kids in the car. Like, be mindful of your weapons. There is kids in the car.
And what else do you tell them?
So as I'm backing up, and as I'm backing up and they're putting me in handcuffs, then I'm yelling too about how there's a gun in the door. So
Why are you telling them there's a gun in the door?
because it's loaded, and specifically it's in condition 1, so there's a round in the chamber, and the only reason is just because I didn't actually clear it afterwards. I didn't like take the magazine out and like unchamber the round. I just left it, just put on safe, left it, or set it in the door, the driver door.
Why did you tell them that the gun was there?
But just to make sure that they knew that there was a gun in the door. Like, I don't want them, like, whatever, bumping it or like grabbing it accidentally or just something, whatever. Just trying to be safe and just letting them know where a weapon is in the car.
And then were you taken into custody?
So yes, and then that's when, yes, specifically I'm put in that one police cruiser. The detective did come up to me prior to, in the doorway, and he didn't really say much. He was just asking if I was okay, and then two, if I wanted anything, if I needed food or something.
So let's talk about what happened when you were interviewed by the police, or when you spoke to the police.
Yes.
Why did you decide to give up your right to remain silent and talk to the police?
And I felt like that was the right thing to do. I mean, I didn't have anything to hide. I'm still trying to figure it out. I'm like, maybe I can talk this through, and like they'll help me try to figure this out of what just happened. But I'm just trying to do the honorable thing, just trying to do the right thing.
How long after the incident did you speak to police?
So this was, I don't know how, like 15 hours? Like 15 hours later. So really short time. So, I mean, too, again, I'm clearly in shock too, because I don't know, like, again, I'm still trying to figure out like the what, the why, the how, like, what is going on. But yeah, anyways.
And tell us what's going through your head. You know, what's kind of your emotional state while you're being interviewed?
So I'm not thinking of like, legally I'm justified, so this is completely fine. I'm thinking, no, I just killed someone, but not just someone. This wasn't just like a random person that was in the house. This was Caitlyn. This is the mother of my kids. This is like, I'm feeling just this incredible, really personal guilt of like, how did this happen? And there's this battle in my head of, I don't feel like I did something. Like, I don't feel like this is my fault. Like, I didn't want this. Like, I didn't put this position together. Like, I wasn't the one who brought this all together. I'm not the one who was like holding Elwyn hostage in front of me. I'm not the one that like was trying to plan all this stuff. Like, but at the same time, I still fired the shot. So I didn't know. I felt this really big, just personal guilt.
In your police interview, you told police it was definitely very fast and deliberate. And then a moment later, you said it was very, very fast, very deliberate. What did you mean when you said it was fast and deliberate?
So, again, with the fast, again, this, like I said, the entire process maybe took 3 seconds, like maximum 5 seconds. So again, incredibly fast. But two, I'm speaking about the physical action. I'm not talking about any sort of mental state. I'm talking about the physical action. But what I mean is like how meticulous it was, like how perfectly performed it was, to where, and especially with how fast it was, for everything to happen within 3 to 5 seconds, like those 2 steps, grabbing it, chambering it, the 3 steps back at the same time, the grabbing Elwyn, the firing, it was so fast and so meticulously performed. That's what I was trying to express.
So like the physical action was deliberate?
The physical action, yes.
You also told the police, it doesn't matter if she was threatening, I understand the consequences. What did you mean when you told the police, it doesn't matter if she was threatening, I understand the consequences?
Because again, this just goes back to like the biggest thing with all of this, like with everything, regardless of anything. My children don't have a mom anymore. And there's just this incredible personal guilt of, like, even without me understanding what had happened, and now even too, when I do understand what happened, now, like, I could have prevented this situation from happening. I could have been this better partner. I could have been a better leader, to where she would not have to even plan this out. Like, she wouldn't have to go to people like Brenda or be coerced into trying to do stuff like this. Like, I should have been this better person, to where this situation shouldn't have even happened.
You told the police that you didn't know if you wanted to address whether you regretted shooting Caitlyn, and that it felt like a trap question. Why did it feel like a trap question?
So either response felt like the wrong response. So if I said yes, that I regretted shooting her, then that would mean that, oh, so previously I did want to, but now I don't. Well, that's incorrect, so that felt like a wrong response. But then if I say no, then, oh, then that means, oh, then I just don't care that she's dead, which is also a wrong response. So it felt like whatever I said was just not the right answer.
Along the same lines, you said, not that it even justifies anything, but she's just my everything. What did you mean by that?
So again, like I don't mean to just keep rehashing the same thing, but obviously Elwyn's the purpose in my life. I mean, she really is my everything, and just like trying to understand what had happened. Just trying to figure out, like, did it matter? Like, how much did that matter? Did it matter that she was hurting Elwyn in front of me? Did it matter that she was holding her hostage? And I'm just, again, I just felt so horrible for it that I'm just trying to, I don't know. I'm trying to do the right thing.
Give me 1 minute, Dustin. Dustin, at this point, I don't have any more questions for you.
Okay.
Your Honor, is this an appropriate time to take our morning break?
I was waiting to see what you would prefer. Okay, all right, members of the jury, we'll take a morning break now. It's before 10:15, so we'll get started at 10:25. We'll resume at 10:25. Again, please do not discuss the case amongst yourselves, and if anyone does, please report that to a bailiff. Thank you.
All right.
Court will be in recess. Thank you. Please be seated. Mr. Duren, again, you're still on rules. Thank you.
May I proceed, Your Honor? Mr. Duren, you testified on Friday that it was January 19th of 2024 when Caitlyn first sent you her flight information as to how she was going to come to New Hampshire with Valen. Is that correct?
Yes,
And you hadn't quite left from Minnesota at that point. You were in fact still there until the 20th, the next day.
yes,
So it was on January 19th that you knew that Caitlyn's ticket from Minnesota to Boston was for two people, correct?
well, it was a single ticket, but yes, with both, because Valen was only one at the time,
And you knew that it was a round-trip ticket for two passengers, correct?
yes.
But your intention was, and the thought was, that Caitlyn wouldn't bring Valen back to Minnesota, that you would keep her there with you, correct?
Yes,
And you wanted Caitlyn and believed that Caitlyn was going to go to Minnesota again after that.
for a few more months, yes,
She then was gonna move to New Hampshire and live about 2.5 hours away from you?
and if that was what she wanted, yes,
Were you gonna let her, you weren't gonna let her move into your house in Berlin, correct?
as I said earlier, I would have, if she wanted to have the conversation, I would have talked about it.
But you've testified and you have heard your statement where you told the police that your plan, as you discussed with your mom, when you would have victory was for when you had the girls and Caitlyn was gone, correct?
Because that was what was always the plan.
Now, you made it clear to police that you're a very calm person, correct?
Yes,
You do your best under stress,
I think so, yes,
and that's what you told them, correct?
yes,
Now, you've talked to us today about this Marine threat level that you function with in your daily basis, correct?
yes,
But as being a Marine, you were taught how to deal with stress, correct?
yes.
That's part of what that MCMAP training is, the Marine Combat Martial Arts Program.
Well, that's not about stress, but about drilling and training.
Well, it's a three-part process, right? It teaches you about intellectual stuff, mental training, as well as physical and disciplinary training, correct?
Sure, yes,
And so it teaches you as a Marine, because that's a high-stress job, right?
yes,
And you need to be able to assess threats, but still make decisions, correct?
yes,
All right. Now, you told the police that you only yelled at Caitlyn one time on January 29th, the day you killed her, correct?
yes.
But today you've testified that you were yelling at her, you were screaming at her, what's going on, give Elowen back, correct?
No,
No, you
I
weren't
s-
screaming at all?
I said this was the one time that I did yell.
So you
The
yelled
one
once,
time, yes, the one time where I was yelling, yes.
and you yelled just once, one yell.
Okay, maybe it was 2 sentences.
Could it have been more than 2 sentences?
No,
You were pretty frustrated, weren't you?
I was having justifiable emotions with my child being held hostage in front of me.
And those
But
emotions
yes.
were frustration, correct?
You could say that, yes.
Anger, correct?
No, I don't think so.
You weren't angry, you just said she was being held hostage. That didn't
She
make
was.
you angry?
I was frustrated, yes, but I wouldn't go so far as to say that I was angry.
But it caused you to yell just once, and that's one of what, 3 times in your entire relationship.
Yes,
Now, there was no time on January 29th of 2024 where Caitlyn hit you, correct?
no,
She never struck you?
no,
She never struck Elowen?
no,
She never struck Valen?
No.
In the moments before you shot her, you described to police that she was holding Elowen in a bear hug, correct?
Yes.
Today you've described it as a one-arm hold. Fair to say?
No, the bear hug was in the third attempt, the final attempt.
Okay, but before that, Caitlyn was only holding Elowen with one arm.
Sure, yes,
Caitlyn was 5 feet tall.
yes,
She was 114 pounds.
about, yeah,
Okay, well, you heard the medical examiner say he weighed her naked body, and she was 114 pounds, correct?
okay, yes,
Now, you are about 5'10", correct?
yes,
On your license, it says you were 190 pounds, fair to say?
yes,
You're bigger than she is,
yes.
stronger than she is.
But that has nothing to do with when she's holding my child hostage and restraining her.
Mr. Duren, you're bigger than she is, correct?
Yes,
You're stronger than she is,
yeah,
correct?
yes,
You've had martial arts training, correct?
yes,
You know how to fight with your hands.
yes.
And yet, when Caitlyn was holding Elowen with one arm, you couldn't get her away.
Without hurting Elowen, no.
Your testimony today is actually that you shot Caitlyn because she hurt Elowen in a moment when you tried to pull her away, correct?
Yes.
She had no weapons?
Well, actually, I should
Mr. Duren,
clarify.
You've answered the question. You had no weapons? I'm sorry,
I had?
She had no weapons?
She did not have a weapon, no.
She did not have a knife?
She did not have a knife, no.
Where you were standing, you had 2 pocket knives behind you in the room, correct?
In the bedroom,
In your bedroom?
yes, behind me,
The front door was behind you.
yes,
Where you were positioned in the living room, she would have to go through you to get to the back door, correct?
yes, that's why I didn't want to leave the immediate area, why I had to keep constant visual on her and Elowen.
But you didn't have constant visual on Valen, correct?
Sadly, no,
Caitlyn did not have a gun, correct?
no.
You had the gun.
Well,
Right.
the gun was, technically, the gun was closer to her, but there was a gun in the room, yes.
Now, let's talk about that. Caitlyn was at your house. She spent the night.
Yes,
At some point, however, even though you were nervous, because you've described that the whole time she was there, you wanted her to leave, right?
I wouldn't say I was nervous that night or the morning,
But you wanted her to leave.
yes,
You were suspicious, right?
yes,
Because you hadn't expected her to come to the house.
no,
You testified that that made you nervous, correct?
yes, yes,
So you were nervous.
okay, yes,
Now, you have a gun safe in that house, a gun lockbox, right?
I do, yes,
It's in the back bedroom, right when you walk in from the back door, correct?
yes,
You didn't put the gun in that lockbox, right?
no. The gun is always near me.
Except when it's in the lockbox?
I guess it would depend on the situation, but it would have been rarely in the safe.
When the gun was on the desk, you weren't sitting at the desk, correct?
I was previously,
You
but
didn't pick up the gun when you walked away from the desk?
no.
So the gun isn't always near you, fair to say?
I always have visual on it. This is something that is instilled in you from the Marine Corps. You always know where your weapon is. You always are aware of who's around it.
Was it instilled in you in the Marine Corps to leave your gun out on a desk if you're nervous about the other people who have access to it?
Again, I know who is around it at all times.
You've testified that you were nervous about Caitlyn, correct?
Sure, yes,
Okay, and you testified today, you didn't tell the police, but you testified today, or I guess on Friday, that you had taught Caitlyn how to use that gun, correct?
yes,
Okay. And today, you testified that you were concerned because she was in close proximity to the gun, right?
which is again why I wasn't leaving the room.
But you were concerned, and that's what you've testified today, that Caitlyn was in close proximity to the gun, right?
Yes,
Part of that concern that you thought maybe she might go for the gun?
and I can't say hypotheticals, but that was the point of me staying in the room and constant visual on her and Elwyn.
Well, you can't say hypotheticals, but you sure testify that you didn't know someone was outside your door, correct?
Yes,
That's a hypothetical, right?
I suppose so, yes.
You can't say hypotheticals, but you sure testified that you weren't sure if Caitlyn had texted somebody to come to the house, correct?
Yes,
You can't say hypotheticals, but you sure testified that you didn't know if Caitlyn had brought other people with her from Minnesota, correct?
yes.
Now, I want to talk to you a little bit more about your calmness under stress. You told a story on Friday, the third story, I believe, about what happened to you in Las Vegas, right? You were directed to talk about the third thing. And
Yes,
so let's talk about that third thing. In Las Vegas, one night when Caitlyn was at work, correct?
yes, I believe she was babysitting someone, yes.
Okay, but that's work, right? She was making money doing that?
Yes, yes,
You were at home and you heard a person try to get into the front door, correct?
yes,
That person was a stranger?
yes,
You didn't know them?
no,
Had no reason to have feelings for that person?
no,
No love for them?
no.
You picked up your gun when you heard that person at the door, correct?
Yes, after bringing Elwyn upstairs and made sure that she was safe upstairs and not to move.
Left her in a place in the house where you didn't have eyes on her, correct?
They would have had to got through me to get to her.
You picked up your gun?
Yes,
You made sure that it was loaded with a clip in it?
and it was loaded previously, but yes.
Okay. You racked the slide to make it ready to fire?
It was, at that point, actually, it was already loaded.
So you already had it ready to fire?
Yes,
So when you told the police in your statement that you are a person who never keeps the gun with a bullet in the chamber, that wasn't quite true, correct?
never, I guess I shouldn't have said an absolute like never, but a majority of the time, it is in condition 3, not condition 1.
Okay.
So normally without a round in the chamber.
So when the person was trying to break in your front door and you picked up your gun, it was already ready to go, right?
Yes,
Was the safety on?
yes,
Did you turn it off?
no,
So you approached the stranger at your front door with a loaded gun ready to fire, but the safety's still on, correct?
yes, that is how you train. You don't take the safety off until immediately before you fire, and then you immediately put it back on.
And holding that gun, you told the stranger to leave.
Yes,
Holding that gun, you told the stranger that you were armed, correct?
yes,
Holding that gun, you opened your front door to the stranger and said you should go, correct?
yes,
Holding that gun, you showed the stranger your weapon, and you said, look, I'm armed, correct?
yes,
You told the stranger you could shoot, correct?
no, but
Pretty much
I'm
implied.
flashing it, yes, yes,
You had called the police that night.
yes,
Your muscle memory didn't take over, right? You didn't just shoot the stranger,
because the stranger wasn't holding my child,
but the stranger was trying to break into the house where your child was located.
but I was in between that person and the child, and they
But-
were never in the house.
And you didn't shoot that stranger in the head, did you?
No,
You waited for the police and the stranger just walked away.
well, they continued banging on windows and trying to get in through windows, and then eventually left as I stayed downstairs and monitored.
So this person not just knocks on your door and attempts to break in, but now they're breaking through windows. You don't see your child and you don't shoot.
They
correct?
didn't actually break a window, but they were banging on windows, yes.
You testified that on February the 14th of 2024, you called the Berlin Police Department, right?
Yes,
And you called them because you just had a fight over the phone, so you say, with Caitlyn, correct?
yes,
And that was about custody, correct?
yes,
And in that phone conversation, is it fair to say that Caitlyn made some of the same statements you've testified she made on the 29th before you shot her?
yes,
You say that she was demanding money, she wanted the kids on her taxes, She was never gonna let you see them again, and she was gonna bring them back to Minnesota, correct?
Yes,
So to call the Berlin Police Department, you had to look up that phone number, correct?
I did, yes.
You spoke with somebody for over 6 minutes at the police department, didn't you?
Okay, yes.
On February 29th, you had your cell phone with you, right?
I couldn't say where it was, but
You had it while Caitlyn was at your apartment?
yes,
You had it the whole time that she was there?
yes,
You had it the every 15 to 30 minutes that you walked in to ask her to leave and she ignored you?
well, I wasn't seeing a threat at that point.
But you were nervous.
I was, yes.
You testified just now that that made you wonder what the plan was, what she was gonna do, whether something was afoot, correct?
But I don't think that would be appropriate to call the police over.
But then, after those, you didn't shoot her then either, correct?
No,
So after going into the room every 15 to 30 minutes, and let's be clear, this is from lunchtime, correct, until it gets dark.
yes,
So
so,
let's say from noon till maybe 5 p.m.?
sure,
Okay,
Yes.
just as an average, right? So 12 to 1, 1 to 2, 2 to 3, 3 to 4, 4 to 5, 5 hours, right? At any time during those, either the 5 hours or at any time during the day prior to shooting Caitlyn in the head, you never tried to force her to get out of your apartment, correct?
no, I didn't physically try to force her out of the home, no.
You knew that you could, right?
Because I'm stronger, I guess?
Well, you've in fact
Sure.
made her leave a home before, correct?
Your Honor, may I approach?
Sure.
Mr. Duren, you've made Caitlyn leave a house before, correct? Yes or no?
No,
Court's indulgence. Mr. Duren, at no time before you shot Caitlyn in the head did you call the police and tell them that she was refusing to leave your home, correct?
No,
At no time before you shot her in the head did you call the police and tell them that you were afraid that she was going to harm your children, correct?
that's correct.
At no time before you shot her in the head, at any point during that day, did you call the police and say that you were afraid she would take your children, correct?
I did prior to that, but not that day, no.
You mean the February 14th phone call, correct?
Yes,
You didn't call the police back, correct?
no,
You didn't call back the officer that you spoke with for 6 minutes?
no,
You had set it up so that they were aware, correct?
yes.
But you never bothered to call them that day and say, hey, get this woman out of my house, correct?
Because at the point that this was happening, this was a moment-to-moment situation. I couldn't take my eyes or my focus off of Elwyn or Caitlyn.
Between 12 p.m. and 5 p.m., you asked Caitlyn to leave approximately, what, 12 times?
Well, yes, but that didn't seem appropriate enough a reason to call the police over.
She was staying in your house against your will, correct?
I was trying to figure out the plan.
You were not concerned enough that you needed to call the police to have her leave, correct?
At that point, no.
But even though you wanted her to leave, you did nothing to make it happen.
I was
Correct?
trying to figure out the plan.
Mr. Duren, after you shot the police and you've testified here today that you didn't understand what had happened, correct?
Can you clarify? I
You
shot the
testi-
police?
After you shot Caitlyn, you have testified today that you did not understand what had happened, correct?
Yes, I was trying to figure it out.
You were trained as a Marine, right?
Yes,
You know what happens when you fire a gun at somebody, correct?
yes,
You know what the intention is when you point and fire a gun at somebody, correct?
yes,
And that intention is to kill.
yes,
You knew that you had done that you had killed Caitlyn, correct?
I didn't consciously realize that it was Caitlyn until, like I said, I was in the car with Elwyn.
So you knew that there was somebody dead on the couch in your living room, right?
My focus was Elwyn.
And you knew that it was Caitlyn who had set you off and made you grab the gun.
I don't know if I would say set me off, but yes,
Well, you
yes,
described it as a tick, right?
yes,
Setting you off, it's a tick, right?
hurting my child in front of me, yes,
Okay. And your testimony today is that that is the reason why you fired.
yes,
After you shot her, you didn't call the police to report that you had just killed somebody inside of your own apartment.
no,
You didn't call the police and report that you had done that because somebody had hurt your child, correct?
no,
You didn't do that to say to the police, hey, I thought they were gonna kidnap my child, correct?
correct,
You didn't call the police and say, hey, I thought that my child was being held hostage and I had no choice, correct?
I did not call the police and tell them those things, no.
You never called the police, did you?
I called my parents and told them to call the police,
You
yes.
agree that's not calling the police, correct?
Technically, no.
Not technically, sir. It is not calling the police to call your parents who live thousands of miles away. Fair to say?
Okay, yes.
Now, Mr. Duren, you and Caitlyn ostensibly, for lack of a better term, broke up in August of 2023, correct?
Well, I guess a couple weeks before, end of July. But
End of
yes,
July?
yes,
Okay.
yes.
And since that time, you've engaged in different arguments about the children, fair to say?
Sure, yes.
About their custody, who they should live with more often than not, fair to say?
Sure, yes.
You've had the same arguments since you broke up that you've described to us here in your testimony today, right?
Not to that extent, but yes, yes,
Okay. But you've had arguments about money since August of 2023.
yes,
You've testified that those arguments involved Caitlyn asking you for more money, correct?
yes,
You've had arguments about how much time the other parent should get to spend with each child, correct?
no, not how much they should spend. I always wanted to try to keep it 50-50.
You wanted to keep it 50-50, but since August, you've seen Valen, I think you said 93 times, and Caitlyn had her 48, correct?
Or I think it was 98 and 48 and then 15 split. But that was a lot of what Caitlyn was telling me about was just how difficult it was to try to work and also care for the kids at the same time. So it was just making sense with me having them more. That wasn't me demanding that I needed them more, no.
Okay. But you wanted to have full custody of them with her elsewhere, correct?
No, absolutely not.
You testified that you've spoken with attorneys in both Nevada and Minnesota, correct?
Yes,
You never filed for custody in Nevada? Correct?
no,
You
No.
never filed for custody in Minnesota, correct?
no,
You never filed paperwork with any court, correct?
no,
There is no court order that gave you sole custody of these children, correct?
no, I didn't want full custody or sole custody.
And there was no court order that took away Caitlyn's rights to custody of the children, correct?
No,
She, in fact, and you had the same or equal rights to both children, correct?
Objection, speculation.
Overruled.
that's correct, yes.
Now, when you walked over to your desk to pick up the gun, you picked up the gun, correct?
Yes,
You've testified that you racked the slide.
yes,
That placed a bullet in the chamber, correct?
yes.
You left the safety on at that point because you were not quite ready to fire?
Well, I'm fairly certain when you rack it back, the safety gets flipped off because the hammer is back.
Caitlyn saw you pick up the gun, didn't she?
I'm sure she did, yes.
Caitlyn heard you rack the slide, correct?
Your Honor, may we approach?
Is when you rack the slide, correct?
Sure, yeah.
Yeah, you can hear it, right?
You can hear it.
You heard it in this room when Jill Terrio racked a slide on an unloaded gun, correct?
Yes,
So you can assume if Caitlyn's sitting closer to the gun than you were, she heard it, right?
yes.
She reacted, didn't she?
She did not, no.
Caitlyn didn't ask you what you were doing?
Maybe she attempted to say that?
Well, did she attempt to say, "What are you doing?" or did she say, "What are you doing?"
I can't say.
Mr. Duren, do you recall what Caitlyn did that was her attempt to say, "What are you doing"?
No.
Mr. Duren, you've reviewed all of the evidence for this case, correct?
I hope so, yes.
Okay, you've spoken to your attorneys about it?
Yes.
You've gone over any reports that were created?
Your Honor, can we approach?
I apologize, Your Honor.
Yeah, members of the jury, I'm going to strike the last question and answer and just indicate that relative to any instructions or conduct between Mr. Duren and his attorneys would be attorney-client privileged, and you are to consider, not to consider the last question and answer. Thank you.
Thank you, Your Honor. Mr. Duren, I'm showing you what's been marked for identification purposes as State's Exhibit 33 in this matter. Just looking at that header, and I'm not asking you to read anything out loud, but looking at this document, do you recognize it?
Yes.
It's a document that was prepared, correct?
Yes.
Okay. I'm going to ask you to take a look at this document. I'm going to ask you, counsel, for your information, it's on page 2 of that document. I'm going to ask you to take a look at the third paragraph, and really it's towards the bottom here. I'm going to ask you to read those to yourself, and you look up when you're done.
Okay.
Does that refresh your recollection as to whether Caitlyn asked you what you were doing with the gun?
I'll just say, I'm not going to comment on what someone else said. I said someone else said.
told someone that Caitlyn had asked you what you were doing with the gun, correct?
I'm not gonna say why someone else said I said something.
But that doesn't refresh your recollection that Caitlyn looked at you after she saw the gun, after she heard the slide rack and said, "What are you gonna do?" Correct?
She did not say that, no.
Well, let's look at another document associated with that. Say Exhibit 34 for identification. And I ask you to take a look at this document right here where the tab is marked, and you can look at the whole thing afterwards. It's underlined on the page that's tabbed. Have you seen that report? That's a draft copy of that report you just looked at, right?
Well, that would be the same person, so yes.
And that same person is somebody that you met with, spoke with, and provided information about this incident, correct?
Sure, yes.
Okay. Someone who you've described in messages as the key to everything, correct?
No.
That report where it says, and Caitlyn nonchalantly,
Your Honor, may we approach?
so Mr. Duren, after you picked up the gun, racked the slide, you walked back over to where Caitlyn was on the sofa, correct?
Yes.
Did you walk around the coffee table to get there?
Yes.
You grabbed Elowen with one hand,
Yes.
had no issue taking her from Caitlyn at that moment, correct?
I never took her and never said I did. I pulled her back. The reason being to create some sort of distance, for two reasons, to create some sort of distance between Elowen and the threat, and then two, to control Elowen while I took the shot, just to make sure that she didn't, like, all of a sudden jerk in front of the path or something like that.
So you were holding Elowen back with one arm, correct? Controlling her.
Yes.
You were holding the gun in the other arm, your right hand.
Yes.
You extended your arm to fire, correct?
No. So, I mean, it could be helpful if I actually showed the exact positions, but my hand would have been, like, as I'm leaning forward over because the table's over here, the couch is in front of me, I'm leaning forward, because Caitlyn's leaning back against the back of the couch with Elowen. So I'm leaning forward, grabbing her, and then the gun would have been probably back here as I'm firing.
And you're firing like this?
Well, whatever this motion is, yes.
Without looking through the sights?
No,
Without
I was
aiming
not
in any
looking through
way?
the sights, no. I was absolutely aiming, yes,
With your hand behind you or next to your body?
yes.
So you couldn't see the exact location where that barrel was pointed, correct?
When someone fires a gun tens of thousands of times, you know where it's aiming at all times.
You know where it's aiming when you're standing like this with your gun here.
Absolutely.
You know if your elbow's not cocked in the wrong position. You know if you're off by an inch. Is that fair to say?
Yes.
You testified when, or actually you told the police, they asked you if you knew where you had shot Caitlyn, correct?
Yes.
And you told them you did, exactly.
Mhm.
You described exactly where on her head she was shot, correct?
Yes.
On the side of her head, in a place where it was covered by her hair.
Yes.
You know, Mr. Duren, you testimony today. Just want to go through a couple of things in there. Oh, before we get to that. After you shot Caitlyn, that's when you began loading the car, correct?
Afterwards, yes.
You packed food and water.
Yes.
You took pillows and blankets.
Yes.
You took multiple changes of clothing for you, correct?
I just grabbed clothes, yes.
Multiple changes, correct? Multiple shirts, multiple sweatshirts.
Sure, yes.
You grabbed multiple changes of clothing for Elwyn.
Yes.
You grabbed multiple changes of clothing for Valen.
Yes.
You testified today that you took your work computer because that's a necessity.
That's why I'm guessing I grabbed it, yeah.
Because you were running, right?
I needed to get out of the area immediately, yes.
Because you had murdered Caitlyn.
No, absolutely not. I guess I should clarify, yes, I had shot her, but at no point did I ever think that it was murder. No.
But you ran.
I got out of the area and made sure that my kids were safe, not just physically, but mentally.
Well, after you shot Caitlyn, there was no danger in the house, right? Just her body on the couch.
Yes. But again, I didn't know if people were coming or what was going on.
You didn't know if the police were gonna come, right?
I guess, yeah.
And so you turned off the lights, you deadbolted your apartment, and you fled, correct?
Well, I don't even really remember doing that, but if you say that happened, then sure, okay.
Well, you heard the testimony of the
Yes.
people who went into your house, correct?
I did.
That
So,
there was a deadbolt, that they had to ram your door open.
well, again, I don't even know if I had the key to the actual doorknob, but the deadbolt was just how you locked that door.
Okay, but it was
So-
very important to make sure that it was locked in those moments that you left, correct?
No, I guess it was just something that I did.
So
Hey,
you
you
f-
leave the house, you shut the lights off, and you lock the door.
So you fled. You drove south, correct?
I like southwest, yes.
And after you called your parents, you went dark, correct?
Yes,
And you did that so you wouldn't be found, correct?
because I wanted to spend more time with my kids and make sure that they were mentally okay.
And you knew the police were gonna look for you because there was a dead body in your apartment, correct?
I did, yes.
Now, that phone call with your parents, your testimony today is that all you did was say, "We're safe, I killed Caitlyn," and that was it, correct?
I mean, there was a little bit more, but yes, essentially, yes.
Well, there was a lot more, right? Because it was a 13-minute phone call, correct?
I mean, okay,
I mean, you saw the records, you have those.
yes,
You spoke to your mom for 13 minutes before you turned off your phone and went dark, correct?
okay, yes.
Even after you decided to turn yourself in, you didn't call the police and say, "Hey, I'm gonna come turn myself in," correct?
At no point did I call the police, no.
And you never actually went to the police, correct?
No,
You drove past police barracks. correct?
Yes.
And in your statement to police, you said it was because you were gonna have breakfast with your girls, right? But you'd already had breakfast with them in New York, according to your
Well,
testimony today, correct?
Brunch, because the time I don't remember exactly what time that was, but like 10:30 or 11. But
You wanted to
Yes.
delay being with the police or turning yourself in for as long as you could, correct?
not as long as I could, but it's probably fair to say that yes, I was delaying it.
Now, Mr. Durham, before you left your apartment after you'd shot Caitlyn, did you check to see if she was still alive?
I knew she was not. But no,
So you didn't
I
check?
never specifically went up to her body, no.
So while you were packing this house over the course of minutes to load your car, you never checked to see if just maybe there was a chance she was alive?
I knew that she was not.
You never called 911 just to be sure? To get an ambulance to protect the mother of your children, Caitlyn, who you were so devastated about having shot, correct?
Correct.
Her being dead is what you wanted when you pulled the trigger, correct?
Absolutely not.
Well, you're a Marine. You're trained in using a gun, correct?
Yes.
You know that the only reason to point a gun at somebody is to kill them, correct?
Yes.
So when you fired, that's what you wanted.
No. All I was thinking of was Elowen. My focus was Elowen. My entire mindset was save Elowen.
Well,
This was not about Caitlyn.
Mr. Duren, you were saving Elowen from being squeezed too tight, correct? From being pulled away from you, correct?
From being hurt. Yes.
And you've indicated here that it was your Marine training that kicked in, correct?
It was, yes.
And your Marine training tells you that when you point a gun at somebody, it's to kill, correct?
Yes.
And so the end result that you knew would happen when you pointed that gun at Caitlyn was that you were going to kill her, correct?
In a very, very basic sense, I guess so, yes.
You didn't shoot to wound Caitlyn, did you?
No.
You didn't shoot her in the arm?
No.
You didn't shoot her in the leg?
No.
You shot her in the head because that would kill her, correct?
Sure, yes.
I mean, Mr. Duren, your defense here today that you want to be justified is that you acted purposefully with deadly force to kill her because she was hurting Elowen. That's your defense, right?
Yes.
But yet you're still hesitating as to whether that's what you wanted.
Because I never wanted Caitlyn dead at any point.
Except as a Marine, you knew the moment you pulled your gun and aimed it at her that that's what your goal would be, correct?
The goal was to eliminate a threat to my child.
The goal was to eliminate the child's mother, correct?
The goal was to eliminate a threat that was holding my child hostage and hurting her in front of me.
And that person was your child's mother who had just as many rights to hold that child as you did, correct?
Tragically, yes.
Mr. Duren, in your testimony, well, again, your defense is that you shot Caitlyn and that it was justified, correct?
Yes.
We heard the detailed statement, you sat here with us and listened of your 2-hour interview with officers, right?
Yes.
And you've also testified here today.
Yes.
At no time during that statement you gave to officers, right after this incident happened, did you tell the police that you had to kill Caitlyn to protect Elowen, did you?
I didn't specifically say that, but with me describing the event, I described that.
You described that Caitlyn wouldn't let go of Elowen, correct?
Yes,
You described that she was holding Elowen in a bear hug, correct?
yes,
You told officers that her not letting go was the tick that caused you to shoot her.
no. The tick was her screaming. Or I think in the interview I said her yelling.
Well, isn't it fair to say that during the interview you actually never said that Elowen yelled or shrieked, correct?
I did say that. I said, I think specifically I said what is big in my head is Elowen yelling
Well, that was after the
or
movie.
screaming or yelling.
That was after you fired.
No, that was just before.
Court's indulgence.
Yes.
Trying to narrow this down for you, Mr. Duren. I believe I'm going to show you what's marked for identification purposes as State's Exhibit 27. I believe that, Mr. Duren, you're welcome to look through this, but most of the actual incident starts on about page 58, moving forward. Once you go ahead and look through that transcript and tell me, or tell us, or look up when you find where you told the police that Elowen screamed before you shot Caitlyn.
Are you sure this is the right area? Is this where it is?
You're welcome to look through the entire transcript, sir, if you want to find it.
I mean, I'm sure my attorneys know. I just don't know if you're expecting me to go through the entire thing right now to find it.
Well, Mr. Duren, you're saying that you told the police that, correct?
Yes.
On page 59 of the transcript, actually, it's really the bottom of page 59, you describe the shooting, correct? You say, I grab it, chamber it, grab Elowen, pull her back, and shot, correct?
Yes.
And then you say it was very immediate. Obviously, what was big in my head is Elowen went yelling. She definitely heard it. And you're describing her reaction after the gunshot, correct?
No, no. That's what I'm talking about.
Oh, you're saying.
Obviously, what is big in my head is Elowen yelling.
So, let's just follow through. Page 59 of the transcript. It reads, after a couple of times of me trying to grab Elowen, and her not letting go, it was
Your
very
name,
fast,
Coach.
very deliberate.
Your Honor.
Overall,
Is that fair to say that that's what the transcript was indicating, sir?
That it was indicating what? $59.
So you're talking to the police in your statement about shooting Caitlyn, correct?
Yes.
You described the shooting of Caitlyn.
Yes.
And then you say, after you shot, Elowen went to yelling.
No. I'm saying, it was finger snap, very immediate, as in my reaction to her being hurt was very immediate. Obviously, and quote, obviously what was big in my head is Elowen yelling.
And that follows with, she was complaining about the loud noise in her ears, correct?
And then there was pauses about how I really hope, I don't think she saw anything.
So describing her reaction after the shot was fired, correct? You were hoping she didn't see anything?
Later, yes.
At no time during the interview did you tell the police that you had killed Caitlyn because she was going to be kidnapping Elowen, correct?
I had suspicions, but I didn't know of any specific plan, no.
And you didn't tell the police about those suspicions that she was going to kidnap Elowen, correct?
The point of me talking about the previous situation with Valen in Nevada, that was part of that, me explaining that.
At no time did you tell the police that at the moment right before you shot Caitlyn, that Elowen was being hurt by Caitlyn, correct?
I did.
You told the police that Caitlyn had Elowen in a bear hug, correct?
Yes.
That Elowen was crying, possibly because you were arguing, correct?
I said because she was being hurt and because of the arguing prior to.
You said because Caitlyn was holding her tightly, correct?
I mean, sure. Yes.
In fact, you told police that Caitlyn had never threatened to harm Elowen, correct?
She never directly threatened to hurt Elowen, no, but she was still doing it in front of my eyes.
Today, in fact, you've testified and used the word hostage, and you've testified to say that Caitlyn was holding
Yes.
Elowen hostage in front of you in your home, correct?
And yes, because even though I was describing a hostage situation and Sergeant McLaughlin knew I was because he asked me about hostage type situations, I never actually said the word hostage. So I'm clarifying that yes, I'm specifically saying hostage, yes.
Right, even when Sergeant McLaughlin gave you that opportunity, you didn't say it, correct?
No, I did. I said yes.
Well, he only asked you if you had training in hostages, correct? That's the question you were answering.
If I had trained in hostage type situations, and yes. Meaning, yes, this was what was going on, so, and yes, I've had training in this type of situations.
Now, today, Mr. Duren, you've testified that before you shot Caitlyn, you begged her to let go of Elowen, correct?
Yes.
You never once told the police that during your interview with them, did you?
That would be weird if I didn't.
You testified today that while you were trying to take Elowen from Caitlyn, Caitlyn braced her foot on the living room table and pulled back, correct?
Yes.
You never told the police that information during your interview, did you?
This is the whole point of me being here right now, is to be as clear and concise as possible, to add details so that there is no more misinterpretations of what I said.
Well, Mr. Duren, you wanted to talk to the police, correct?
I did, yes.
You knew that you were talking to them about the murder of Caitlyn Naffziger, correct?
At no point did I ever think that this was a murder.
You knew it was important when you talked to the police to tell them everything, correct?
Well, even he said that there was a million things that I would probably think of to say.
And those million things are actually the details now of this offense, correct?
I take my oath right now very, very seriously, and I'm telling the truth.
You've testified today that on the day that you shot her, Caitlyn was demanding that you pay her more money. You said an unheard of amount, correct?
A substantial amount, yes.
You didn't tell the police that information either, did you?
Did I not? I mean, I was certainly talking about her threatening. I guess I don't directly recall if I said if it was specifically about money or not.
When
But
we say threatening, you mean her threat to call the police and take the kids, correct?
yes,
Today, you've testified that on the day that you shot her, Caitlyn told you that you'd never see your children again, correct?
yes.
You never told the police that during your interview with them, did you?
I guess I do not recall.
In fact, you told the police about that money situation that Caitlyn, on the day before you shot her, said that she told you you needed, and I don't know how to phrase this, so give me 1 second, that Caitlyn told you that you needed to sell your car to give her the money from that sale, correct?
Oh, are you talking that
That day?
that day?
Yes.
Yes, yes, if I couldn't get her that money, that then I needed to sell my car and give her the money from the car.
You didn't tell the police that information either, did you?
Again, the purpose of me being here is to be as clear and concise and give every detail that I can possibly give so that there cannot be any more misinterpretations.
Well, 1 moment, Your Honor.
Yes. Okay. Redirect.
So the state just tried to claim that you didn't tell the police that she was threatening to take the kids away, right?
Yes,
They
yes,
just asked you, and you just said, "Did I not?" Question mark.
yes,
It would refresh your recollection if I showed you the transcript of all the times you told the kids that, right?
yes, it would.
All right. Judge, may I approach with what's been marked for ideas? With what's been marked for ideas states 32.
Yes.
Page 57.
Do you want me to say it?
Lines 1 and 2, does that refresh your recollection about whether or not you told the police that she was threatening to take the kids away?
Yes.
Okay. What
Your
did you,
Honor, if I can just object, that refreshing recollection, Your Honor, the defendant did not indicate he did not recall.
he said, "But didn't I? Did I not?" was his answer to your question.
Counsel approach.
Sure.
did you tell the police that she threatened to take the kids away that night?
Yes.
Do you know how many times you told the police that?
I don't know how many times, no.
Would it refresh your recollection if I showed you the transcript?
Yes, it would.
'57? Take a look at page 58. Take a look at page 81. See if it's there multiple times on page 81.
Yes.
Check page 83.
Your Honor, I just ask if the defendant is answering the question or if counsel is counting for him.
Overruled.
I'm sorry, did you say 83?
I did say 83.
I see it.
And so we can't be sure, it's a long transcript. At least how many times did you tell the police?
At least 5 times.
At least 5 times? And did the police indicate to you that they thought that that was what you had said?
Yes.
I'll take that transcript back from you. You best to put it back in order if you can.
Yeah.
You testified earlier that when this was happening, when you were seeing your child being held hostage in front of you, you weren't angry. Were you afraid?
Absolutely.
What was different that night than past arguments about custody?
Yes, I was able to, for the most part, brush off past arguments because, and the difference being now is because my child wasn't being held hostage in front of me and used as leverage.
And there was some back and forth about the fact that you told the police that Elwyn was yelling.
Yes.
When you told the police that Elwyn was yelling, what were you talking about? When was this yelling happening?
I'm specifically talking about right before the third attempt when I tried to grab Ellen for the third time and she pulled back, bear hugging, squeezing Ellen and twisting and yanking her backwards. That yelling.
And the state interrupted you once or twice when you wanted to clarify why this happened. But I think you said ultimately The goal was to eliminate a threat who was holding my child hostage in front of me and hurting her. Is that accurate?
Yes, yes it is.
That's all I have right now.
Recross?
Very briefly, Mr. Duren, the last question the state asked you, the one that counsel has just gone in and had you count inside of the transcript, let me ask you again. You testified today that Caitlyn told you before you shot her that you would never see your children again. Is that your testimony today?
Yes,
And that is something you never told the police, correct?
that specific sentence, maybe not.
It's not what was on page 57 or page 58, correct? That you just looked at with counsel.
Okay,
It's not on page 81 or 83, correct?
okay,
Is that a yes, sir?
yes,
Because you never told the police that Caitlyn made such a threat that day, correct?
if you are insinuating that I'm lying right now, that is not true. I am here clarifying, being as clear and concise as I possibly can be.
No other questions.
Okay. Can Mr. Duren step down?
Yes, sir.
Okay.
Your Honor, the defense rests.
Thank you. Okay, counsel approach, please. Okay, defense is rested. Anything further from the state relative to rebuttal?
No, Your Honor, the state has no further witnesses and rests.
Okay, all right, thank you. Members of the jury, the evidence is now closed. At this time, there are several things that I have to attend to with the attorneys, as is standard in a matter such as this. So what we are going to do is we are going to break for the day. Okay, we are going to break for the day. You'll be dismissed for purposes of today and to return at 9 o'clock tomorrow. At 9 o'clock promptly, we will start closing arguments by both the defense and by the state. And I will instruct you tomorrow, and you will have time tomorrow to begin your deliberations. So again, tomorrow morning at 9 o'clock, you'll hear closing arguments, you'll hear my instructions, and then you will receive the case tomorrow. So I'm going to stop for the day here. Again, please do not discuss the case with yourself. Do not discuss the case with anybody else. Please avoid any media coverage relative to the matter. Please conduct no research whatsoever about any matter that you've heard in the courtroom. Please do not transmit anything by way of your own social media. You've been very faithful to my instructions so far, and I have no doubt that you will between now and tomorrow. So again, we'll reconvene at 9 o'clock tomorrow. Go directly to closing arguments, and you will have the case tomorrow. Okay? Thank you. Dismissed for the day. To court and be in recess until 1 o'clock. Thank you. be seated. Okay, good afternoon. We are here outside the presence of the jury. The jury has been dismissed for the day to review jury instructions. Attorney Kennedy, before lunch, before we broke, you did make a motion. Would you like to state that further on the record?
Yes, Your Honor, just briefly, thank you. I'm moving to dismiss all 4 charges for insufficiency of the evidence, even when viewing the evidence in the light most favorable to the state, no rational trier of fact could find beyond a reasonable doubt that the state's presented sufficient evidence to overcome their burden of disproving defense of others with respect to all the charges. Specifically, and I'm looking at paragraph 2 of physical force in defense of a person, 627:4, subparagraphs B, C, and D. We concede that A is not applicable, but B, C, and D, based on the evidence presented, are all applicable. Specifically, a person is justified in using deadly force upon another person when he reasonably believes that such other person, B, is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. And that would be the evidence here that Caitlyn was restraining Ellen, using unlawful force against her, and not leaving the home when Dustin was telling her to, because her purpose was either to kidnap the child, interfere with custody and bring her across state lines, commit theft by extortion, or theft by deception. And that would be the facts related to her coming to the apartments, overstaying her welcome, demanding money, making threats that she's going to take the kids and never, and Dustin will never see them again. Excuse me. C is committing or about to commit kidnapping. Again, with all those facts that we have alleged through the state and through Mr. Duren's testimony, that her behavior and her comments show that she was about to or intending to commit a kidnapping. And D is likely to use any unlawful force in the commission of a felony against the actor within such actor's dwelling or its curtilage. And I don't believe I misstated this earlier, Your Honor. I would argue that I got it right, that the unlawful force is Caitlyn using unlawful force against Ellen while committing a felony against Dustin within Dustin's home. And that felony being any of the ones that I enumerated already: interference with custody, kidnapping, theft by deception, theft by extortion. And so for all of those reasons, we have presented evidence the state has not overcome, and the court should dismiss all 4 charges.
Okay, thank you. Counsel?
Your Honor, I'll ask that this court deny the motion. I believe the court already did deny it. I'll ask it to make that record clear. I'm going to cite the State versus Perez. Does not yet have a formal citation. It's 2025 New Hampshire 6, dated February 7th, 2025. And in State versus Perez, the Supreme Court discusses the standard that applies in a sufficiency challenge at the close of the state's case and after the close of the defendant's case as well, when the defendant has presented evidence. The court says that evidence presented in a defendant's case in chief could tend to disprove or discredit the evidence introduced by the state. Nonetheless, this type of evidence is immaterial to the trial court's analysis because the trial court must view all of the evidence and all reasonable inferences from it in the light most favorable to the state. Consequently, the trial must construe conflicts between the state's evidence and the defendant's evidence in the state's favor when it's analyzing the sufficiency of the evidence challenge. Accordingly, the trial court's analysis of whether the state introduced sufficient evidence to prove the defendant's guilt would be the same regardless of whether it is conducted in response to a motion raised after the state rested its case or at the close of the evidence. That is the controlling law here. With regard to the facts, again, the standard is in the light most favorable to the state, whether or not there is sufficient evidence for case. I won't try and properly state that double or triple negative that we discussed before, but there is certainly sufficient evidence for any rational trier of fact to find in the state's favor here. I think we strayed into a bit of a charge conference there with defense counsel's argument, but with regard to each of the different varieties of justified force in defense of a person, I think the state has certainly presented the necessary evidence for a rational jury to find that the defendant did not act in self-defense. I'll note for the court at this time, I'm sure we'll get into this more, but I'm going to quote from my notes here of what the defendant said during his direct examination and his cross. Defense counsel just, I'm not sure why, but defense counsel just said that they don't believe they're going to make an argument about subsection A, where someone is about to use unlawful deadly force against the actor or a third person as a reason for justification. My notes indicate that that is exactly what the defendant testified to, and that's the only thing he testified to the exclusion of other reasons. The defendant said, and again, these are my notes, so it's words to the effect of, he shot the victim because she hurt Elowen. During testimony about the multiple attempts to take Elowen from the victim and take Elowen from Caitlyn, there was that third attempt that was unsuccessful, and at that point, according to the defendant today, a line was crossed. Elowen was being physically hurt in front of me. My threat level went from orange to red. There was immediate danger and threat to Elowen. I had to take action immediately to save Elowen. I think the import of those is clear. The defendant told us that his entire mindset was saving Elowen, and in conjunction with those other things, it is abundantly clear the defendant took the stand today and told us exactly what his purpose was in saving Elowen. It had nothing to do with a burglary. It had nothing to do with extortion or theft by deception or any of these other things that Caitlyn was supposedly doing while remaining unlawfully in his home. The state would not concede that she was remaining unlawfully. The defendant had not, I don't think, called the police and told her she needed to leave sufficient to have her trespassed. She was there with her child. So we wouldn't concede that she was remaining unlawfully, although the defendant certainly testified that he wanted her out of the apartment. With regard to kidnapping, again, I think we'll get into more of this at the charge conference, but the defendant testified that, yes, over the course of the day, he had these suspicions that maybe someone was outside in the car. There was someone, there were lights in the window, and he didn't know if Caitlyn had brought anyone with her. But that was not his stated purpose in why he took the lethal action that he did. He was very specific and very clear that while these threats about money and other things are being made, after that third attempt, in his own testimony, a line had been crossed. He went from orange to red. Elowen was being hurt. I shot Caitlyn to save Elowen because Elowen was being hurt. That is self-defense or defense of another in response to the use of deadly force. That's 627.4.2a. That is not B, C, or D. I would disagree with counsel's interpretation of D. I think the wording of that is pretty clear, that it requires that the person who is using the deadly force believes that the other person is likely to use any unlawful force against the actor, not unlawful force against anyone while committing a felony against the actor. I think the other language in the statute makes it very clear where, even in B, the statute says is likely to use any unlawful force against a person present while committing or attempting to commit a burglary. D makes it very clear that the force is against the actor. It doesn't say against anyone in the home, or make it clear that the force can be used against anyone while the felony is against the actor. That doesn't make any sense. So for all those reasons, Judge, I think the motion to dismiss at this stage should be denied.
Okay, thank you. Anything further, Attorney Kenny?
Nothing, Your Honor.
Okay, once again, we're here. The first order of business relates to the motion to dismiss raised by the defendant previously before lunch. We will get to the charging conference and jury instructions, and I will explain what that is in just a second. But with respect to the defendant's motion to dismiss, the motion to dismiss is denied. for the reasons articulated by the state. I would also reference State versus Perez as referenced by Attorney Spicer, and relating back to all of my arguments that were in the citations that were indicated at the close of the state's evidence, which was on Thursday, if my recollection is correct?
Yes.
Thursday? Okay, so I relate back to Thursday for purposes of the initial motion to dismiss, which was denied, and I would deny the defendant's motion to dismiss again at this time for the reasons stated previously and for the reasons stated by the state, not with respect to A through D, but at least with respect to the referencing of State versus Perez, 2025, New Hampshire 6. So motion to dismiss is denied. Excuse me. Now, with respect to jury instructions, for those who may not be familiar with this process, those other than counsel who may not be familiar with this process, sometimes this is referred to as a charging conference. The jury instruction process, what we're about to do, relates to the specific sentences and paragraphs that I am going to provide to the jury after closing arguments with respect to the law that applies to the case. This is the opportunity for counsel for both sides to describe and argue on behalf of their side what law should apply, what law I should give the jury as it relates to the instructions that are given to the jury. The jury instruction booklet that typically is used is a large 3-ring binder, and what we do in this process is we narrow that down to say what does the jury need to decide as part of this process. So it can be sometimes a lengthy conference, and that is why I sent the jury home for the day, so that we can have plenty of time to make sure that everyone has developed a sufficient record on both sides relative to the issues that we are about to discuss right now. Also, for the record, I previously gave the first half of my instructions to the jury before opening statements, and I'm going to come back to that in just a second. Next, I will state for the benefit of everyone that I did circulate a very rough draft of jury instructions to counsel at the end of the day on Friday, so that they would have the weekend to be able to review them and make their comments, be prepared to make their comments about what part of the jury instructions should be altered, what should be added, what should be taken away. And that's also what we're about to do right now. And there's one other thing I was going to say. But we can't finalize the jury instructions until we know exactly how the evidence has been completed. And now that the evidence has been completed, it gives the opportunity for everybody to make arguments about the appropriate way for me to instruct the jury at this point in the proceeding. So, in terms of how we go through this, I know that we are going to take quite a few detours as is necessary as part of the process. But what I will indicate to counsel, I guess the first question I have is, in any case in which there is an extended period of time, read that to mean any case that lasts over a 3-day period, especially one that goes over a weekend. I guess the first question I have for counsel is whether or not there is a preference that I go back and read the first half of my instructions again, instead of just the second half of the instructions. I don't know if anybody has any position with respect to that. I have done it before where there's been a request that I go back and read all of the instructions from the beginning. Any comment on that, Attorney Duren or Spicer?
The state doesn't feel strongly about it, Your Honor, but I do think that out of an abundance of caution with the case of this gravity and with the length of time that has elapsed since the originals for the first instructions were given, it would make sense to deliver those again. Because I think there are a number of topics in there that would be valuable to deliver to them again with regard to credibility of witnesses, that sort of thing.
Okay, all right. Counsel?
No position, Your Honor.
No position? Okay. All right. Based on that, and I want to state in that regard that one of the dangers in doing that, of course, is that if they are going to place special emphasis on the part that they heard before, however, I think that risk is mitigated by virtue of the fact that it does contain, there's typical language in there that says, please do not single out any instruction for any special emphasis. So the fact that they're hearing a portion of it a second time, that risk is mitigated or ameliorated by virtue of the fact that there's a separate instruction saying, please do not place special emphasis on any one instruction. So defendant has taken no position. State thinks in an abundance of caution, and the court agrees with the state. I will read the entire amount of the jury instructions from scratch. I realize that they are lengthy, however, I do think in this case it is important. It just dawned on me what I forgot to say to those who have not been through this process before. So I'm taking one step back. The other reason why we do this, of course, is because counsel, experienced and competent counsel on both sides, want to be able to frame their closing arguments based upon the law that I'm going to give to the jury. So in other words, when they prepare their closing arguments, it is of great benefit and necessary for them to know what the law is going to be, how I'm going to instruct the jury, so that they can tailor their closing arguments to the instructions that I'm going to give. So closing arguments will come first, jury instructions second, but we're talking about the jury instructions now so that the closing arguments for both sides can appropriately be tailored to fit those instructions that they're going to hear after the closing arguments. So once again, that is why we're having this particular conference at this time. Okay, next order of business with respect to the draft that I circulated. First, the copy I circulated should have page 10. Any issue with respect to page 10, counsel? Okay, on to page 11. So now with page 11, I guess the first question becomes, and my question will go to the state, the way I've structured this, the way I've structured it, once I get to the bottom of page 11, would be to include the elements there. What the defendant has proposed as part of their instructions is to include the self-defense element as directly as part of those elements in the first recitation of the elements for the second-degree murder knowing charge. State's position with respect to the defendant's structural argument to place the defense of others element into page 11 and 12. Attorney Spicer.
Your Honor, just to be clear, are you referring to including the defendant did not act in self-defense as an element? Or are you referring to including the larger body of self-defense instructions at this point?
And that's whether we say self-defense or whether we say defense of another. Do I include that element, assuming that I give it, which I know we're going to argue about here in a second, but is that structurally, do you have an objection to structurally me putting it in there, not relative to factual support, but relative to the structural component, the architecture of the instruction, so to speak?
And again, Judge, just so I'm clear, when you refer to the architecture, are you referring to the greater amount of instructions on self-defense generally, and whatever versions that you might find appropriate, or are you referring to adding an element to each charge?
Do I understand your question completely? Do I adopt what Attorney Kinney proposed?
Well, I guess I'll address both.
Yeah.
In my experience, I think there's no wrong way to do it. I do think it makes more sense logically and structurally to get into the elements of the offense first and then self-defense afterwards. So here's what the elements of secondary murder knowing are, reckless in each charge, and then self-defense afterwards. That mirrors, I think, the way the case comes in with the state's case and then the defense's case. I don't have any case law for Your Honor on whether or not there's a right way to do that. So I guess the state's position is that if it were up to us, we would propose charges first, or elements of each charge and each offense first, and then self-defense afterwards. With regard to whether or not there should be, second-degree murder, the elements are cause of death of another, do so knowingly, and then number 3, not act in self-defense, if the court finds that's appropriate. I think the case law says that there's either way is appropriate. There's case law that makes very clear that a court's choosing to instruct just on the elements of each offense and then instruct generally on self-defense and make clear during that general instruction that self-defense instruction applies to all charges. That is satisfactory. That is not erroneous or in any way legally problematic. I know it's been done both ways. Adding an element is not legally incorrect. So I mean, I think the state was satisfied with the structure that Your Honor interpretation on that, either of those two topics is wrong.
Okay.
So that's what I would say.
Okay.
Judge, I think the case law, while it says it's not reversible error not to add as an element, the case law is clear that the court should add as an element. So I'm going to read from State versus DuPont, 165 New Hampshire 698. And DuPont references the framework outlined in State versus Soto, 162 New Hampshire 708. So in DuPont, they say, here then, it is enough to say that when the defendant is entitled to a specific instruction on both provocation and self-defense, which I understand that's not necessarily where we are here, trial courts should add disproving self-defense as an additional element of the offense that the state must prove beyond a reasonable doubt. So I think that the Supreme Court has indicated a clear preference. I think the reason for that is that it is the clearest and fairest way to instruct the jury. I think it becomes much more confusing to address self-defense kind of abstractly separately from the elements of the charged offense. The law is clear that when there is some evidence of self-defense or defense of others submitted, then the failure to act in self-defense becomes an element the state must prove. And so the court should instruct that it is an element the state must prove in accordance with the settled law in State versus DuPont.
Okay, all right, thank you. Anything further?
No.
Okay. All right, and so let's go right there, Attorney Kettles, with respect to, let's assume that I'm going to grant your structural argument as it relates to where the elements apply. Okay? Let's assume that I'm gonna grant that, where it should apply. So tell me, with respect to second-degree murder, knowing, how you want the proposal, let me find it, that I've received from you or from Attorney Kinney. The one that I received indicated that the defendant did not act in defense of another.
Yes, Judge, and so just to make it clear, we did essentially start at the bottom of page 11 and submit an entire version on Sunday, which I trust the court received.
Which I have, B, which I thank you for, and I'm following right along.
Thank you. And so it should say, the defendant is charged with a crime of second-degree murder. The definition of this offense has 3 parts or elements. And then I think we track your language, except that we then add a 3rd element, and the defendant did not act in defense of another. Then there's the knowing instruction, which I believe is the same. And then, Judge, on page 2, 3, and the top of 4, we provide our proposed instruction on self-defense, and I can read it into the record, but I don't think it's necessary as we've submitted. I'm sorry, it's defense of others.
Yes.
When I say self-defense, Judge, please just assume I mean defense of others. I think it just makes the matter clearer to the jury if we use the phrase defense of others rather than self-defense, since we're not, at this point, we're not arguing that Mr. Duren acted in defense of himself, but rather he acted in defense of Ellen.
Okay.
And so we ask that the court adopt our proposed language on self-defense, which, or defense of others, which tracks the statute, and I think accurately states the law.
And I know why you're rising, Attorney Schweischer, and we'll, please make an outline as I am, so that we can go through each thing step by step. I know why you're rising. I don't want to interrupt Attorney Kettles at this point.
And Judge, I'll note for the record that our proposed instruction tracks the instruction that was given in another case in this court, State versus Nomar Ramos Rivera, docket 214-2023 CR 26. It also, I believe, tracks instructions that this court has given in, what was your case?
Green.
State v. Hunter Green. And then another case that Attorney Harding told me about but didn't tell me the name of, so I'm sorry that that's not very helpful, but
Coble.
perhaps the court remembers.
Coble.
Yes, and so I think it's the instruction that the court has used before, both you, Judge, and the prior judge who sat here. It's an instruction that's based largely, I think, on the language that the Attorney General's office uses when discussing use of deadly force by police officers. The standard is the same for people who are not police officers. They should be entitled to the same instruction. It's a correct statement of law.
And Attorney Kettles, just to follow along, I think it was just a typo, but with respect to the submission, I assume that on top of page 2, that, once again, defense?
Yes, Judge, anywhere I'm using self-defense, please
Sure.
make that mean defense of others.
Certainly. Okay.
And I don't think the headings are read to the jurors, so
They are not, but they do get copies of these,
that's true, Your Honor.
so,
I apologize.
okay. Okay. Okay, once again, assuming for purposes of this discussion that I will be altering the structure to be that which was requested by the defense attorney Spicer. With respect to the entitlement of the defendant based upon the facts relative to any of the defenses,
Thank you, Your Honor.
any of the pure defenses, I should say.
First, just as to the characterization of we're only dealing with the defense of another, I think defense counsel argued earlier with regard to under 627-24C that their theory was that the defendant actually and reasonably believed that under their interpretation, Ms. Naffziger was going to use unlawful force against him, or use unlawful force against Ellen in the commission of a felony against him. I think that does bring us back into self-defense rather than purely defense of another if there's a felony being committed against him. So that's just a characterizational note.
And can I stop for a second? So with respect to 627-4, 2A, and referencing the argument that you made during the motion to dismiss, I would just point out, right, that A says is about to use unlawful deadly force against the actor or a third person. You've referenced Mr. Duren's testimony as it relates to the perception of force being used by Ms. Naffziger against Elwin. However, you would agree that he was not perceiving deadly force against her.
I agree.
Okay, I just want to make sure.
So with regard to what instructions the defense is entitled to at this point, the
Yes.
state's position is that the defendant is entitled to an instruction on 627-4-2A based on his testimony. And again, the import of his testimony. So first, Your Honor, I'll try to structure this. With regard to B, C, and D in 627-4, those subsections, the state believes the defendant has not shown, and there is no evidence sufficient to meet even the low bar for a jury instruction. I believe the standard is some modicum than a mere iota. I don't have a case site, but I believe
Scintilla.
more than a mere scintilla, yes, that is my understanding of the standard. The defendant took the stand and told us exactly what his mindset was. He used those phrases that I quoted, and again, those are from my notes, but he said, in response to a question on cross-examination, he agreed that he shot the victim because she hurt Elwin. And that is the import of all of his statements. While the defendant certainly testified that over the course of that day, leading up to the murder, he had in his mind some suspicions about things that were going on, and that Ms. Naffziger was making threats against him and asking him for money and telling him that if he did not provide her with money or did not sell his car, she would do certain things or call the police or take his children away from him. His testimony is very clear that when it came to the point that he is trying to get everyone into the car so he can drive them all back to Hampton, he is attempting to remove Elwin from Ms. Naffziger's arms. She refuses. There are multiple attempts, and after the third attempt, he told the court and the jury that the line was crossed. Elwin was being physically hurt in front of me. The threat level went from orange to red, and I perceived an immediate danger or threat to Elwin, and I had to take action immediately to save Elwin. That is why he acted. He did not act, I think it is clear, by omission in his testimony. He did not act because he believed that Caitlyn was in the process of, commit a burglary by committing any other crime while remaining unlawfully in his home. I think that is imputing an intent to Ms. Naffziger that is not present. We don't have any specific testimony or evidence about whether or not Ms. Naffziger remained unlawfully in the home with the purpose to commit a burglary by committing any predicate crime. But I certainly don't think that standard has been satisfied for purposes of a jury instruction, particularly in light of the defendant's testimony. With regard to C, kidnapping. I know that there's been a lot of litigation about this, but while the defendant said today that he believed, or that there was suspicion in his mind that Ms. Naffziger was going to kidnap the children, that's not what he told the police in his statement. And it's also not what he said today about why he actually committed the killing, why he pulled the trigger. Yes, he had these suspicions, but he called them really just suspicions. In that vein, Your Honor, I think the state of the evidence, as according to the defendant, is important to take into account here. At the time the defendant pulled the trigger, by his own account, Ms. Naffziger was sitting on the couch. The crime scene photos tell us that she had one foot up on the table. She was not wearing any shoes. The defendant, by his own admission, was between her and any knives that were in the apartment. He was between her and the doorways. She could not exit without going through him. She was unarmed. She had not threatened to hurt him or to hurt Ellen or to hurt Valen. Given all of those things, and what I have referenced multiple times now about the defendant telling us what his entire mindset was, there's no evidence that he killed Ms. Naffziger because he actually or reasonably believed that she was committing or about to commit a kidnapping. The moment in time that matters here is the time that he pulls the trigger. And at that moment, for him to merit a jury instruction on kidnapping and self-defense, he had to actually believe that she was committing or about to commit a kidnapping, and that belief has to be reasonable. And that's not what his testimony was, and it's not reasonable. There's not even a mere scintilla of evidence that would support that that's a reasonable belief if he held it. And his own testimony here today has told us that he did not. I think the same argument applies to subsection D about whether or not the defendant actually and reasonably believed that Ms. Naffziger was going to use any unlawful force in the commission of a felony against anyone, him or Ellen, however that statute is construed. The defendant's testimony today and his statement to the police was that Ellen was not, the victim did not threaten to harm anyone. For him to say now, at this stage, that he actually and reasonably believed that there was a likelihood that Ms. Naffziger was going to use unlawful force against either himself or Ellen is just not supported by the evidence, particularly in the commission of whatever felony. The defendant's claim that he believed that there was this kidnapping or that there was interference with custody going on, this other crime that I think will become relevant in a minute, I think is also not supported by the evidence, where for Ms. Naffziger to kidnap her own children, to commit the crime of interference with custody by taking them away or concealing them from the defendant would require her to leave. It would require her to do something other than remain in his apartment holding the child. And there's no evidence that she did anything of that nature. And again, she had no car, she had no bus ticket, no family or friends close by. She was not wearing shoes, she was not dressed for the weather. The defendant's own testimony was that he shot her and he pulled the trigger because she refused to let go of her child. That is not her committing or about to commit a kidnapping. She's not running out the door into a waiting car. She's not taking Ellen and Valen and hopping onto a bus when the defendant's not looking. That's simply not what the testimony is. I'll reference the degree of force jury instruction here as well. The court included it properly in the rough draft. I think it should be there. Obviously, as it should in every case involving self-defense and deadly force. There is no evidence that the defendant actually or reasonably believed that he used only the right amount of force necessary to commit, to act in his own defense. Whether he's doing it to defend Ellen or himself, to defend the kidnapping or otherwise. Ms. Naffziger was wearing no shoes with one foot on the table. She weighs half of what the defendant weighs, or roughly half. She's significantly smaller. The defendant testified that he is a trained Marine. He's been through boot camp, he's been through infantry training. He has this martial arts training that allows him to disarm anyone. His own testimony was that Ms. Naffziger was holding Ellen, although there's a dispute over this. According to the defendant, in in the light most favorable to him, Ms. Naffziger was squeezing Elwin, perhaps enough to make her shriek. We don't accept that that's what the evidence is or what the evidence shows or what actually happened, but that was the defendant's testimony to some effect. By his own admission, Ms. Naffziger was not armed. She did not have access to a deadly weapon at the time that he pulled the trigger because he had the only gun in the apartment. And he said the only knives in the apartment were behind him, some distance away. They were certainly not readily close at hand. He didn't say that. They don't appear anywhere in the crime scene photos. The defendant shot Ms. Naffziger in the head. He is, by his own admission, an expert marksman. He has trained hundreds or thousands of Marines on how to shoot their weapons and how to use those to hit your target and eliminate threats. He testified he didn't shoot Ms. Naffziger in the arm. He didn't shoot her in the leg. He shot her in the head because that was his purpose. He told us today that he absolutely did aim when he fired his gun. So I think the import is very clear. It was his clear intent that he executed to shoot Ms. Naffziger through the side of the head where her hair was covering the side of her head. That is not proportional, and there's no evidence that was only the degree of force that was necessary. There's no evidence that any rational juror or trier of fact could find that. So I don't think the defendant has met the bar or satisfied their burden to obtain a jury instruction on self-defense under any of these varieties. While I am making this rather lengthy argument, Judge, I'll just state, I think to wrap up, if the court is inclined to give an instruction on self-defense in the kidnapping version, it should be specific and it should include a definition of what kidnapping is. The defense has not supplied a definition of what kidnapping is, although they argue that it is not the definition that's contained in 633.1. I think they have rather pointedly not defined it. And I don't think it is appropriate for this court to leave that open-ended and essentially allow the defendant to define his own version of self-defense in the kidnapping version. If the court is inclined to give a self-defense instruction relative to kidnapping in 627.4, 2C, we think that the court should instruct the jury what kidnapping is and what it is not. That kidnapping is, and I think we'll reference the statutory definition, that a person commits the crime of kidnapping if the person confines another under their control, the person does so knowingly and acted with a purpose to hold the person for ransom or as a hostage, avoid apprehension by a law enforcement official, terrorize the person confined or some other person, or commit an offense against the person confined. And again, it's our position that the defendant has not satisfied any of these, given the testimony and the state of the evidence. If the court does instruct on the kidnapping self-defense variety, we also think the court should make clear what kidnapping is not, and that relates to interference with custody and 633.1-A. The court has the legislature has specifically laid out what kidnapping is and what it is not in terms of a parent and their child who is related by blood. It cannot be the case that the defendant can receive the benefit of a kidnapping jury instruction for behavior consistent with 633.1-A when the legislature has said that is not kidnapping in this situation as it applies to him or to Ms. Naffziger. He certainly can't obtain the benefit of that when the law clearly says that he is not entitled to it. And I think it's important that the jury know that to prevent some sort of issue with specific unanimity or failure to agree on a specific definition of what kidnapping is. I think I'll stop there.
Once again, thank you, Attorney Special. Once again, with respect to 627.4.2A, I think that there was one point where you argued that the defendant was entitled to that instruction in one place where.
I misspoke, Your Honor.
Just.
I think that's what the defendant testified regarding, but given the degree of force issue and the proportionality of force and the state of the evidence with regard to that, I don't think he's entitled to that or any other.
So the reason, the reason why 627.4.2A would not apply relates to the amount of force.
Correct. The use of
Okay.
bringing a gun to a fist fight, so to speak.
Understood. Okay. Understood. All right. So, so from my perspective, and we'll get further relative to the kidnapping issue in a second, but Attorney Kettles, with respect to, I don't think there's any issue with respect to A, correct?
That's correct, Judge.
So-
We're arguing that.
B through D?
Yes, both on cross and on redirect. The goal was to eliminate a threat who was holding my child hostage in front of me and hurting her. That alone is enough to get defense of others instruction under D through E, but that's not the limit of the evidence. That's not the only evidence in support of the defense of others instruction. And Judge, I think most of the other arguments that the state has made has gone to their perspective on the strength of the defense, not on whether or not the sum evidence standard was met. The sum evidence standard has been met. The court stated that it had been met at the close of the state's case, and since then, even more evidence of defense of others has been presented. State versus Brooks and State versus Woodburn and many other cases cite the same standards. And for the record, Brooks is 2025 New Hampshire 12, and Woodburn is 175 New Hampshire 645. The standard is, quote, for there to be some evidence to support a defendant's specific defense, there must be more than a minutia or scintilla of evidence. The evidentiary support need not be overwhelming. State versus Brooks further explains, quote, when a defendant asserts a pure defense and there is evidence to support the defense, negating such a defense becomes an element of the offense that the state must prove beyond a reasonable doubt. We have held that an erroneous jury instruction relieving a state of its burden to prove an element of the charged offense constitutes structural error, and that structural errors require automatic reversal of a defendant's conviction, end quote. And again, State versus Brooks, when there is some evidence to support a pure defense, a trial court's failure to give a jury instruction on that defense is akin to failing to instruct on an element of the offense. And we have far more than a minutia or a scintilla of evidence here. That one quote, the goal was to eliminate a threat who was holding my child hostage in front of me and hurting her, is some evidence. The additional evidence, and I'm not going to go over it, Judge, I'm going to pick 7 or 8 kind of key points here. There's evidence that Caitlyn actually had a plan to take the children out of the state without telling Dustin. There's evidence that Caitlyn bear hugged, restrained, and confined Elwyn and would not let her go. There is evidence, and by evidence, Judge, I mean not only Mr. Duren's testimony today, but also the evidence that the state presented through its recorded interview, as well as Ms. Palmunden's testimony. While restraining Elwyn, Caitlyn threatened to call the police and lie to them and say that Dustin had kidnapped Elwyn unless Dustin gave her money. Today he testified it was a significant amount of money. I believe the police interview talks about $2,000 a month. Today he testified about her telling him to sell his car, which is certainly worth over $1,000. And so there we've got not only the kidnapping and the unlawful interference with custody, but that's also where some evidence comes in that she remained. This is after he told her to leave over and over again and said, we're going, I'm putting you in the car, we're going. And she still sat there and she made these threats. Judge, that's burglary, that's purpose to remain in the home with the purpose to commit theft by deception, lying to the police, saying that he kidnapped Elwyn in order to get money, theft by extortion. If you don't give me money, I'm going to take your kids away and you'll never see them again. That is felony level unlawful interference with custody, trying to take the kids out of the state. It's a felony against Mr. Duren, and it's also burglary, purpose to remain in the home with a purpose to commit stalking, harassment, and a number of other offenses. An additional piece of evidence, while restraining Elwyn, Caitlyn said Dustin would never see his children again, that she was going to take them from him. Another piece of evidence, some evidence in support of this instruction, Caitlyn pulled and yanked back on Elwyn forcefully enough for her to scream in pain. I think the evidence has been clear that Dustin shot Caitlyn because she was doing these things. He has described this entire situation as being very intense, very chaotic. All of this stuff kind of building up to the moment when the line had been crossed, right, where his goal was to eliminate the threat who was holding his child hostage and who was hurting her. The fact that that's the moment at which he acts doesn't mean he's not acting because of all the other stuff that's happening. He's acting because of everything in combination, and that's the moment at which he can no longer just do this tug of war, right? He has to take further action, proportional action, because of the pain that's caused to the child. That doesn't mean he's not acting for these other reasons. And I think the testimony has also been that Dustin shot Caitlyn while she was still holding Elwyn. So while she was still restraining her, holding her hostage, about to commit a kidnapping, committing a burglary with the purpose to commit all of these other crimes, and using unlawful force while doing so. Dustin's belief was reasonable. it was correct. She had a plan to kidnap the kids. His belief that she was going to do so was reasonable. And Judge, I think I've cited unlawful interference with custody, false imprisonment, and false report to law enforcement, two other crimes that she remained in the home with the purpose to commit.
If I grant you 627.42B, do I have to then define burglary?
Judge,
And how long is that gonna take?
How long is it going to take?
Not with respect to the argument, but with respect to the instructions.
Yes, I think that, so, from a kidnapping perspective, the case law was supported in our memo, or cited in our memo, State versus McDonald, which I've referenced at prior hearings, which is 163 New Hampshire 115, make it clear that the court cannot limit what kidnapping is to the statutory definition, but it's something broader. I think that the court could instruct on burglary and on all of these different offenses, and that would correctly state the law to the jury. If they added in that the state must prove beyond a reasonable doubt that he was not acting because he reasonably believed that she was about to commit a kidnapping, and the state must prove beyond a reasonable doubt that he did not reasonably believe that Ms. Naffziger was likely to use any unlawful force against a person present while committing or attempting to commit a burglary. I think the court could then provide a series of examples of a purpose to remaining in the home with a purpose to commit a crime, and could provide a series of examples of what those crimes might be.
I mean, McDonald talks about the phrase forcible sex offense, which is not coextensive with aggravated felonious sexual assault.
Yes. And it said there, I think McDonald and the other cases that I cite in my memo make it clear that unless it says as defined in the statute, it's improper for the court to limit what the word means to the statutory definition.
So, by providing examples, aren't I in a way limiting?
No, I think the court could provide examples and then say, or any other type of burglary.
But that's a large list.
Yes.
Okay,
But
All
I
right.
think correctly instructing on the law may require a large list, Judge.
okay, please continue. Thank you.
Yes, Judge. And the state is trying to argue essentially different interpretations of the evidence, maybe asserting that there is contradictory evidence, but that doesn't change the fact that the court must give the instruction. State versus Kavanaugh is a case we haven't discussed much yet, but it's 174 New Hampshire 1, a 2020 case. And the Kavanaugh was abrogated by Brooks to the extent that Brooks said, look, this is structural error. But the rest of Kavanaugh is still good law. And there it says, quote, to be entitled to the instruction, the defendant had only to demonstrate that there was some evidence to support it. She did not need to submit proof beyond a reasonable doubt that she acted in self-defense. And it said also, the defendant contends that the trial court unsustainably exercised its discretion because it decided the merits of her self-defense claim instead of determining whether there was more than a scintilla of evidence to support it. We agree. Although the evidence was conflicting, we conclude that there was more than a scintilla to support the defendant's assertion that she acted in self-defense. What the court's asking you to do is basically to decide, or the state's asking you to do, is basically to decide the merits of the claim rather than allowing the jury to do so as it's proper. State versus Woodburn, it's got some interesting language in it about how the jury can make various inferences about mental state, even if the defendant doesn't testify specifically about mental state, that I think are instructive here, but I'll also note that State versus Woodburn says, to the extent that testimony can be construed as contradicting other testimony supporting the self-defense instruction, any inconsistency was for the jury to reconcile, not the trial court. And the sum evidence standard does not require that the evidence presented by the defendant be uncontradicted. So Judge, I think we've got far more than a minutiae or scintilla of evidence here for the subsections of 627.4 B through D. And so the court must instruct the jury on defense of others.
Okay, with respect to C, my question, Attorney Kettles, with respect to C relates to NUCAS, N-O-U-C-A-S, at 165-146. And the issue relates to the kidnapping issue, which is, I just want to make sure I understand the defendant's position. In NUCAS, it appears that Judge O'Neill denied the instruction based upon, my phrase is that It wasn't a question of whether there was sufficient evidence, and it wasn't a question of the court making a credibility determination based upon the evidence. Instead, Judge O'Neill was affirmed when he refused to give the instruction in Nucas because it didn't have the legal predicate for it. And I guess that's why, now we're getting to the point of why I asked for the memorandum in the first place, as it relates to the kidnapping issue, and specifically the 633-1A, if I'm doing this from memory, relative to, the question relates to Nucas, and it relates to legally, not factually, but legally, is the instruction to be given based upon the specific facts at issue here. And I'm asking you that question, and I'll go back to the state with respect to their position as it relates to how this situation relates to the Nucas situation. Excuse me.
And Judge, let me make sure I understand. My recollection of Nucas is that it deals with a situation in which the defendant is presenting a theory of a case rather than a theory of defense. So in
No,
Nucas.
no.
No?
Not by my read. My read, excuse me, my read is that it was a theory of defense. However, the predicate in order to trigger the defense wasn't met. I believe the word any is italicized in Nucas at the relevant, I can get the pin site, but that in this case, there wasn't any evidence that justified the theory of defense. And I could be wrong about that, but I think that's the number one thing I've been looking at. Are you factually, is the defendant entitled from a legal standpoint, not from a factual standpoint? But, once again, continue.
Judge, I'm not sure, I need to reread Nucas, but my notes on it indicate that in that case, he testified to different versions of events than the state alleged, and the defense of others would have been in regards to an offense he wasn't charged with. So he wasn't saying, like, I think in Nucas, let me just make sure I'm right. He was convicted for accomplice to armed robbery, and he essentially argued, I'm not gonna get the exact facts right here, Judge, but he essentially argued, I was justified when I assaulted someone. And the court said, well, you're not charged with assault, so it doesn't really matter. It might not be assault, that's an example I'm using. It doesn't really matter whether you were justified in assaulting because that's not what you're charged with. Your being accomplice to armed robbery has nothing to do with defense of others. And so here, you know, he is admitting to committing the act, and he is saying that the act was justified. And so Nucas is not applicable because the defense of others resulted in the charged offense.
Okay. And so, sorry, excuse me. Sorry to make you get up again, Attorney Kettles. Once again, with respect to B through D, under McDonald, you're asking me to use the expressions with respect to B through D from a colloquial sense as opposed to a strict sense?
Yes, Judge, as it relates to kidnapping, we're saying that that cannot properly be limited to the elements in 633-1. And I want to be clear, in case there's any dispute, I'm not saying 633-1A applies. I know what the word consanguinity means, but that the court would be improper to limit the jury to considering the elements of 633-1.
But you're looking for a colloquial definition as it relates to kidnapping and to burglary?
I don't think that there needs to be a definition of the word kidnapping in State versus McDonald. There was no definition of the word forcible sex offense.
Correct, but they're using it in terms of I think they used a colloquial, the way in which it's defined, as opposed to a statutory definition. I could be off on the word colloquial.
Judge, my understanding is that the court just included the phrase forcible sex offense and explained our statute is clear, the language is not difficult for the jury to understand in McDonald.
Okay, all right, thank you. state's position based on that?
Your Honor, I think I'll refer to State versus Davidson, which was cited by the defense and the state, 163, New Hampshire 462. In that case, Supreme Court interpreted RSA 627-8 relating to use of force in defense of property. And there, they were concerned with the term unlawful taking, and they ruled that it is not limited to merely theft, quote unquote, as defined by statute. But the import of that is that it was not limited to theft because the term unlawful taking can include other behavior besides the statutory definition of theft, similar to forcible sex offenses, which can include a variety of different offenses. Kidnapping is not one of those. So what the court is saying in these cases is that we're not saying as defined by, because we are talking about a larger category of statutorily defined offenses. In Davidson, they made it quite clear that we're talking about the top of a funnel here, not the bottom of it. And so in this case, 627.42c specifically references kidnapping. 627.42b references burglary. Those are specific words relating to specific crimes that are defined by statute. I don't think it is appropriate, the state does not believe that it is appropriate to leave open the definition of those terms to a colloquial definition, which is inviting the possibility that the jury is going to make a decision on an incorrect definition of those terms. I think that's simply not appropriate, particularly in light of the situation. We're not talking about defining these offenses for purposes of a charge of kidnapping or a charge of burglary. We are talking about doing it in relation to the use of deadly force and whether or not that deadly force is justified. And as we make clear in our pleading, I think it's very clear and not arguable that the use of deadly force in self-defense is only available in certain prescribed circumstances, in a very narrow set of circumstances as defined by the legislature. What the defense is asking is to blow that up and allow the defendant essentially to define or leave open for the jury to sort of just on their own define in a colloquial sense, what does kidnapping mean, what does burglary mean. In a situation like this where deadly force is involved, the court should make sure that the jury knows what those terms mean and that they are agreeing on what those terms mean, whatever their verdict might be.
And Judge, the state's argument would ask the court to include language the legislature did not see fit to include, and would ignore the clear guidance in State versus Woodbury 172, New Hampshire 358. And the guidance in Woodbury says that when a statute includes the phrase as defined in RSA X, it is a term of art. But when the statute does not include the phrase as defined in, it is not. And so if the legislature wanted to, it could have made a statute that says a person is justified in using deadly force if he reasonably believes that a person is committing or about to commit a kidnapping as defined in RSA 633.1. We know that the legislature knows how to do that because it does so in a number of other statutes, including the one outlined in Woodbury, including 627.8, and a number of other statutes that I've referenced before, the reckless conduct statute, and other portions of the justification statute. The legislature knows how to make something a term of art by saying as defined in a statute, and it chose not to do so here.
Okay. All right. You want to go to the, I've got my thoughts on that, but we'll keep going right now. Let's go to the defense's request relative to use what, in this geographic part of the state, is colloquially referred to as the NOMAR instruction relative to self-defense. What's been proposed by defendants relative to the NOMAR instruction. The state has proposed the self-defense as it relating to the 2011 criminal jury instructions. Am I correct? 85 or 2.
Proposed anything, I think. I don't know if that's what the court used.
You did propose.
We did.
Yes, back in September.
Oh, yes, I apologize. Yes.
Not recently, but back in
Okay.
the September filings.
Yeah, I think we referred back to the model instructions. Again, I don't think that those instructions from situations can instruct differently, but I think that the instructions in the court's rough draft are appropriate and track the law, track the model instructions with no deviations. I think obviously the instruction that's proposed by the defense are more favorable to the defense, so in that sense we don't believe that the court should give them, but I think either is appropriate.
Okay, thank you. All right.
And Judge, again, they're not wrong, right? The no more instructions are a statement of the law. I'll note that the model criminal jury instructions were actually drafted in 2010, and the Defense of Other statute has been amended since then. And so I think that in and of itself is a reason to give the no more instructions rather than one that a draft instruction not finalized that predates the most recent version of the statute.
Attorney Kettles, if I give the NOMAR instruction, so to speak, what's your position relative to the request from the state to use the degree of force instruction from Etienne?
Judge, I would argue that, I have a couple of arguments about Etienne. The first one is that, again, at least the case itself predates the amendment to the Defense of Other statute, and therefore the court there didn't consider the amendment to the Defense of Other statute. I also think it's important to note that Etienne is discussing a case where a person is, where the claim is that someone is about to use unlawful deadly force against the actor or third person. So there's this kind of built-in proportionality that needs to happen there, right? It needs to be deadly force. Deadly force can be met with deadly force. A slap in the face cannot be met with deadly force. But by contrast, the other three kind of subsections of the statute are things where the legislature has determined if this happens, it's okay to use deadly force. If there's a kidnapping, deadly force is proportionate. If there's a forcible sex offense, deadly force is proportionate, right? This is very different, this subsection, than the rest. There's no requirement that any force be used at all. And so I don't think that there can be a proportionality assessment when there's no requirement that any force be used at all for the defendant's actions to be justified under the law. And I think that kind of recognizes the split-second decision that someone needs to make when they reasonably believe that one of these serious offenses is about to occur.
Okay. Want to proceed to the other two elements? Excuse me, the other two crimes, Attorney Spicer?
If I may just touch on the degree of force, Your Honor.
Certainly.
I certainly don't think it was the legislature's intent to allow the use of deadly force where there is no force used or no degree of deadly force used in any of these other contexts besides the one in 627-4A. In the defense's reading of this, under B, there's a burglary. If I remain in someone's home unlawfully or enter by going into someone's apartment and I tell that person, I'm going to steal your wallet. According to the defense's interpretation of that, if I don't touch them, I don't brandish a weapon, I don't wave a knife in their face, if I just say, I'm staying here, I'm not leaving, and I'm going to take your wallet, they can shoot me in the head. I don't think that comports with the law. There's significant case law on this. Etienne, most of all, besides State versus Mayo as well, 167, New Hampshire 443. Says a person can defend against what he reasonably believes to be the imminent use of unlawful, deadly, or non-deadly force by another, and can use the degree of force that he reasonably believes is necessary for this purpose. I think that's kind of built into the law there, so I'll address that and leave it there. Your Honor, I wanted to move on to what next? I apologize.
Is there anything else before we move on to reckless conduct and child endangerment? Anything else anyone wants to say for purposes of the record?
No, I don't think so.
No, Your Honor.
Okay. Okay, then just want to make sure everybody's developed, before I start making rulings on those, I just want to make sure everybody's got their factual record, their record relative to the arguments that have been made.
I think the one thing I would add, Your Honor, tacking onto the discussion of whether kidnapping should be left open as a colloquial definition, I think it's important for the court to instruct instruct not only on what kidnapping is, but what it isn't, to avoid a situation where the jury, you know, mistakenly or not, believes that the defendant was acting because he thought Ms. Naffziger was going to take his kids away and take them away to Minnesota, which would legally constitute interference with custody rather than kidnapping, because the children are related to both individuals by blood. Ms. Naffziger could not legally be charged with kidnapping for doing that. I don't think it's acceptable to run the risk that the jury, because of the testimony, mistakenly acts on that and acts on a mistaken understanding of what legal definitions apply here. So if the kidnapping instruction is given, our position is it should not only define what kidnapping is and that the defense should be held to which particular theory of kidnapping under the statute they believe the facts support, but also what kidnapping is not, so that there's no danger that the jury is making its decision on a mistaken interpretation of the law.
Okay. Right now it's 2:10, and at some point we'll take a break. And I guess one of the things I'm soliciting input on right now is, should I make some initial rulings right now and have folks proffer their requested instructions as the best use of our time as it relates to what we're doing right now before a break, before we get to the other two charges? If you understand what I'm saying.
I don't think there's a significant dispute for the other two charges, right? We would once again add that the element of defense of others should be added, but I think it perhaps makes sense to get through everything so that we can get the court's actual instructions.
Sure, I want to leave enough time so the council can assist with getting the instructions before 4 o'clock is what we're going to be doing here. I mean, let me make it clear. I'll work all night, but you won't have the benefit of that relative to your preparation of closing arguments.
However the court wants to handle it.
What's that?
However the court wants to proceed.
Let's go with the reckless, let's go with second-degree reckless. I want to hear argument about whether let's do second-degree reckless, and then we'll take a break after that. I'll make some rulings, then we'll take a break. So I guess my question relates to the defendant version includes the defense requested version includes the phrase depraved heart, whereas the state's version, I believe, does not, based upon the jury instructions relative to the manifest and extreme indifference to human life. If I'm wrong about that from the state's perspective, let me know, but I believe that under the model jury instructions proposed by the state that the phrase depraved heart was out
That's correct, Your Honor. I don't believe it appears
in the model instructions. And so I did note that it was present in the defendant's version that they requested. So I just want to I want to make sure everybody has said whatever they want to tell me relative to that specific issue.
I think it's inviting a degree of confusion by adding another somewhat obscure legal term that does not appear in the model instruction.
Okay.
Judge, I think it's been used in other cases with similar charges, and so it's appropriate to use here,
Okay.
and it was upheld in other cases.
Okay, so once again, Attorney Kettles, going back to the NOMAR instruction, you indicated that your position is that is a correct statement of the law. I understand that it's been used previously, but you also indicated as part of your argument that it had been used relative to justified shootings?
Judge, I think that the no more instruction, I believe, was crafted by attorneys Wines and Mayo, and I think that they did extensive review. The footnotes are in my original instructions that were submitted of kind of how the Attorney General's office has handled claims of self-defense or defense of others in the past. And so those footnotes, Judge, are in the original instructions that were proposed instructions that were submitted. Let me find when those were submitted. Back on September 3rd.
Okay.
And so I essentially, it's on page 3, Judge. I think it's essentially an argument of what's good for the goose is good for the gander, that if that's the correct statement of law and it's the standard that the Attorney General's office applies when dealing with officer-involved shootings, that should be the standard of law that the court applies for someone who's not a police officer.
Your Honor, the Nomar case involved testimony from an expert in the use of force. So the use of force was an issue in that case in a way that it is not here. I think those jury instructions were tailored to that specific case. There is no such factual predicate for them in this case, where the defendant is, described the situation that we're in. It did not involve the same or similar facts, similar arguments about those facts, no expert testimony on the use of force here. So I think that, while those instructions were found to be appropriate by the court with regard to that case, that doesn't mean that they're appropriate for this case.
Okay. All right, thank you. I will make some rulings on the record, and then we will take a break, and then I'm going to, during the break, I'm going to be starting to solicit from counsel their specific instructions on a few things. So I will be adding, from a structural standpoint, I will be adding the act in defense of others element to the individual components as it relates to the second-degree murder and knowing and second-degree reckless. In other words, I'll be adding the part that says that the defendant did not act in defense of other. I hereby grant that request of the defendant. With respect to the actual defense of others component, I'm going to deny the defendant's request to use what is being referred to as the NOMAR instruction. With respect to specific uses of individual defenses within 627.4 Roman numeral 2, with respect to A, I think that it's been established that A is not applicable under the circumstances. With respect to B and D, the court is mindful of the directive from the Supreme Court relative to the court's weighing of credibility as it relates to the previously referenced Kavanaugh case, and also the Brooks and Woodburn case. The court is mindful of the court's job not to comment on the merits of the case and to not impermissibly act as fact finder as it relates to Brooks and as it relates to Woodburn and the other cases mentioned. With respect to B and D, however, I'm focusing on the phrase likely to use. The issue relative to likely to use, there's a difference between, under the statute, a difference between A, which uses the phrase is about to, and C, is committing or about to commit. Whereas B and D, specifically the legislature chose to use the phrase is likely to use. Not whether the person is committing or is about to, but rather with B and D, the focus is the adverb likely to use. So based upon the evidence that has been presented, I'm denying the defendant's request with respect to B and D. And again, I am not substituting myself in the position of fact finder. I'm not commenting on credibility, focusing on the phrase is likely to use, both with respect to B and D, as opposed to is about to use or is committing or is about to use, which is a different sentence structure used by the legislature in A and in C. I am going to grant the defendant's request with respect to C. Obviously, we're not talking about a forcible sex offense here. We're talking about kidnapping. So I'm granting the defendant's request as it relates to 624 Roman numeral 2, lowercase c. I'm aware of nucus as it relates to whether there's a legal predicate or not. I believe that the defendant has established that. So what I'm ruling is that B and D are not permissible. I am granting C, and I do think that there needs to be some definition of what kidnapping, what we're talking about as it relates to kidnapping. So I am going to solicit from both parties their phraseology as it relates to kidnapping. Under the law, a kidnapping is blank. In other words, I'm going to grant 627.4 2C. Under the law, a kidnapping consists of, or a kidnapping is defined as, and then I need to have something as it relates to what a kidnapping is. And if the state chooses to propose what a kidnapping isn't, I will view that in the context of what the state, overall of what the state is proposing and what the defendant is proposing as it relates to how 627.4 2C will be applied under these circumstances. And I'm also going to adopt for purposes of ruling right now, I will adopt the Etienne phraseology as it relates to the degree of force, deadly force versus non-deadly force. So that's what those are the rulings as it relates to what we've got to this far. Finally, I will not be using the phrase depraved heart. I will be using the second-degree murder. The remainder of the second-degree murder reckless component with including the manifesting an extreme indifference to the value of human life. The rest of that, but not including the depraved heart sentence. So with respect to this point in the instructions, any questions from the state as it relates to instructions at this point? Attorney Spicer. Okay, Attorney Kettles.
No questions, Your Honor.
Okay, 15-minute break. And anything that I can receive relative to kidnapping, we'll proceed with the other counts. But anything I can get relative to kidnapping will help not just me, but help you. We'll get this done by the end of the day. Thank you. We'll have a 15-minute recess. Please be seated. Sarah, is this me? No, do I? On the desk. Nothing there, nothing.
I don't know what it is.
Okay, thank you. Okay, I've been advised that I am receiving something relative to kidnapping.
Yes, the state filed, I think what the court asked for, proposed definition of kidnapping, and what kidnapping is not.
Okay. Okay, thank you. Thank you. Moving on to reckless conduct with a deadly weapon. Attorney Speicher? Or Duran, whoever's doing this?
Your Honor, the state was satisfied with the draft instructions the court circulated. I think they accurately instruct on the law related to that offense. I believe the court has already indicated that you're going to add the additional element of defendant did not act in self-defense, and that's already been ruled out. But otherwise, the state has no issue with the defense or with the instruction as written.
Okay. Okay,
And Judge, I think all we did was add the fourth element and then take out some of the additional language regarding deadly weapon because I think, and serious bodily injury, because here the manner in which it was, you know what, Judge, actually we're fine with the instruction that the court gave with the addition of the fourth, of the final element.
adding the additional element?
Yes, Judge.
Okay. So I will amend reckless conduct with a deadly weapon, charge ID ending in 222C relative to adding the state's burden to prove that element beyond a reasonable doubt of defense of another. Okay, moving on to endangering the welfare of a child, the, Attorney Speicher?
Again, Your Honor, the state has no issue with the instruction that's circulated by the court. I'll note specifically that the state believes the court correctly identified the distinction between the dual intents there, purposely violating the duty and knowing with respect to endangerment, so we do believe that is a correct instruction.
And position relative to, three options. Do I force, three options. Do I force counsel to argue that there's a duty? Number one, do I request that counsel stipulate that there's a duty? Or three, do I simply enter a finding that there's a duty? For purposes of this draft, without making an order, I posited that it would be within my province to indicate simply, without going overboard, simply to say, under the law, the court has determined the defendant owed a duty of care, as stated in the instructions. So, from your perspective?
I don't know if that's in dispute. I think it's appropriate to certainly take it out of the jury's hands as something they need to decide and make it clear that that element is not an issue. We're happy to stipulate. I don't know where defense counsel is on that.
So Judge, I think it would be error for the court to issue a finding on an element. That is the province of the jury. And the defense is not going to stipulate to an element. It has a right to hold the state to its burden on this element. So we would ask that that language that the court has, it appears in gray in mine, it may be different color in yours, but at the bottom of page 15, under the law, the court has determined to the end of the page that be removed.
Okay, and, okay, if I, based upon the defendant's arguments, which I acknowledge, based upon that, Attorney Kettles, do you want me to do you want the court to define duty of care under the circumstances? And once again, for purposes of the record, in case it's not clear, I believe both counsel already agreed that there is no model jury instruction. There is no model jury instruction that we are aware of relative to this. Am I correct? Attorney Duran's shaking her head yes. So,
Correct.
okay.
Judge, we submitted the proposed instruction that we would ask the court to give.
And the one, just so I'm clear, the one requested by the defendant does not include a definition or reference relative to the duty component?
Correct, Judge.
Okay, so, all right. Okay, any argument? Any argument on that?
No, Your Honor.
Okay, so with respect to endangering the welfare of a child, Attorney Kettles, if I strike the one that was on my page 15, if the pagination has not been changed, the one that was circulated to council, if I strike the sentence that begins under the law, the court has determined, which I'm doing that, is there anything else in my wording that, and if I add not in defense of another, if I add that as an element, if I strike the comment about the court finding a duty, number one. And number two, if I add the not in defense of another element, both of which I'm going to do. The next question, I guess the next question that really I'm getting at next is, in the statute for which there is no model jury instruction, it includes two different states of mens rea. And what I attempted to do and how I wrote it was reference the purposely with respect to violating the duty and the welfare with respect to the effect upon the child. So I understand that the defense has requested their instruction, but if I add defense of another and if I take out the finding of a duty, does the defendant have any position as it relates to the relation of the mens reas, the relation of the two separate mens rea components to the individual action components of violating a duty and the endangering of the child?
Judge, our position would just continue to be that the proposed instructions that we filed on multiple occasions are the best instructions in which we've given in this case. Based on in re and K.
Okay, so my observation, I understand your position. My observation is that the one requested by the defendant does not match up the mens rea with the individual actions, which, if I grant the defendant's request in that regard, my concern is that I'm not adequately providing the jury with the necessary instruction under the circumstances. I'm still considering whether to grant the defendant's request, but I'm trying to find out if you don't want there to be a reference with respect to the mens rea component and the actus reus component.
Judge, I believe our proposed instruction discusses both the mens reas.
Your Honor, I think the court's instruction accurately captures this issue in the statutory language, and I'll cite State versus Bortner, 150 New Hampshire 504.
Okay.
That I think speaks to the interplay of those two, but I think it is appropriate to instruct as the court is doing.
Okay. Okay, thank you. All right, moving on relative to, that concludes essentially the defendant's draft. Moving on to my draft. Again, I'm moving up the defense of another components. I'm moving that up so that it is coming directly after the elements for second-degree murder, knowing, go right into the defense of another component at that point. So now back on my draft, I'm at page 20. My inclusion, the paragraph starting with multiple charges. Position on that? Multiple charges, alternative charges, position from the state?
No position, I believe that's acceptable.
Okay, Attorney Kettles?
Judge, with the multiple charges, I guess my concern is that if the jury finds that Mr. Duren was justified in causing the death of Caitlyn Naffziger, then that should lead to a not guilty verdict on the other charges as well, as any proportionality or any other kind of argument would surely mean that he was justified in his actions that would otherwise constitute lesser offenses.
The state didn't disagree with that. Certainly the jury separate and distinct. There are scenarios where the jury perhaps could find the defendant not guilty of murder, but certainly still guilty of reckless conduct or endangerment of a child.
And I think, okay, thank you. Attorney Kettles, any response?
I think our point is that if the jury finds that the state has not proven beyond a reasonable doubt that Mr. Duren was not justified, then that would result in acquittal on all 4 charges.
I think I'm explicitly positing that possibility by virtue of including a element in each of the individual charge definitions relative to the fact that the state has the burden with respect to each of those individual elements. So I think that that takes care of that. The justification defense is essentially inserted into each of the element definitions in each of their constituent sections. So I'm gonna leave that in as is, okay? Alternative charges, Attorney Kettles?
Same argument regarding the element, right, the only element I think meaningfully in dispute as to the 2 alternative charges is the acting in defense of another.
Okay. Okay. And the rest of it, I hesitate to use the phrase boilerplate, but with respect to the remainder of the boilerplate, so to speak, obviously it is extremely important. By saying that, I do not mean in any way to not indicate how important it is under the circumstances. However, when I use that phrase boilerplate, I'm simply saying it's the same usually from one case to the next. So I don't know if there's any specific challenges to any, or questions with respect to that.
No, Your Honor.
No, Your Honor, just I guess request at some point that we could see the verdict form.
Certainly. No, I should have sent that, that's I'll get that to you instantly, soon. Okay. Anything else right now with respect to the instructions, Attorney Spicer?
No.
Okay, and Attorney Kettles?
Is now the time to discuss the definition of kidnapping?
Yes.
Then yes.
If we're ready to, then yes. Yep.
So, Judge, the state just a minute ago propounded a proposed definition, and I want to be clear that we continue to maintain our objection to defining kidnapping for all the reasons that we've discussed before in terms of McDonald and Woodbury and the other cases cited in our motion. But I think the specific definition proposed by the state, or any definition that's kind of limiting us to the statutory elements, is an issue because the statute says that Mr. Duren would be justified if he reasonably believed that Ms. Naffziger was committing or about to commit kidnapping. And so I think that it's instructive to look at the case law on attempted kidnapping. In State versus Casanova, 164, New Hampshire 563, the court explains that a person commits the crime of attempted kidnapping when, with a purpose that kidnapping be committed, he does or omits to do anything which, under the circumstances as he believes them to be, is an act or omission constituting a substantial step toward the commission of the crime of kidnapping. And Casanova also explains that the state was not required to prove the elements of kidnapping under RSA 633(1) to sustain the charge of attempted kidnapping. And so I think here where we have the possibility that Mr. Duren is justified if he reasonably believes that someone is about to commit a kidnapping, he doesn't need to reasonably believe that each element of the kidnapping statute was met. State versus Bean, 153 New Hampshire 380. The Supreme Court says, we noted that the attempt statute requires the state to identify the intended offense, this is an attempted kidnapping case as well, but does not require the state to plead and prove the elements of the intended offense. Since an attempted crime is by definition a crime not completed, the state could not plead, factually identify, and prove the elements of the intended offense as if it had been carried out. We therefore held that the state was not required to allege in the indictment a statutory subsection of the attempted offense. To convict the defendant of attempted kidnapping, the jury was required to find that with the purpose that the crime of kidnapping be committed, the defendant did or admitted to do anything which, under the circumstances as he believed them to be, is an act or omission committing a substantial step toward the commission of the crime of kidnapping. So the state's proposed instructions, first of all, I think their reference to essentially 633(1), Roman 1A is confusing and inappropriate. But second, it doesn't adequately capture that Mr. Duren would be justified if he reasonably believed that Ms. Naffziger was about to commit the crime of kidnapping based on Bean and Casanova.
So with respect to the defendant's position that the existing phraseology in the jury instructions is sufficient as is and don't define kidnapping further at all, am I correct?
Yes, Judge.
Okay.
That it should track the language of the statute because the legislature has not referenced 633(1). It would be improper for the court to limit kidnapping to the offenses in 633(1).
And I'm reading what the state has filed.
Judge, when the court's ready, I'll have more argument.
Certainly, just a second. So Attorney Kettles, I guess here's my next question. If I don't define kidnapping, in the instructions, and then 10 minutes into deliberations, we get a note from the note that says that a certain juror has been picked as a foreperson. And then 30 minutes after that, we get a note from the jury that says, what is a kidnapping?
Then the court should instruct, use your common sense everyday definition of what a kidnapping is. I think that's what the legislature says. That's what the statute says. Judge, I'll note, in addition on the state's proposed instructions, that they've narrowed it down essentially improperly just to kidnapping and not to about to commit a kidnapping. And then by using that paragraph, it is also important to note certain behavior that does not fall within the definition of kidnapping, followed by a lengthy sentence. Judge, that is certainly including language in 627(4) that the legislature did not see fit to include. And there's many sites, I put them in my pleadings, about statutory interpretation. The court cannot add this full page of definitions that the legislature did not see fit to include in 627(4). The state is trying to use a different statute that's not referred to in 627(4). This is not a term of art. The legislature knows how to create a term of art. It knows how to refer to other statutes. It did not do so here. And so the court is limited. It cannot add language the legislature did not see fit to include, and that's what this entire page that the state submitted is.
Okay, and was that also the further argument?
That was my further argument, Judge.
Okay, all right.
Your Honor, I think the court has already expressed that it is appropriate to define kidnapping to address the very situation that Your Honor just brought up, that the jury may very well wonder what kidnapping means. The most appropriate definition is the one contained in RSA 633(1), and that's what the state has included here. The state has not changed that definition or added to it or retracted from it. We believe that is the appropriate definition, and again, we believe it is appropriate to define kidnapping for what it is and also what it is not. We did include in brackets that a person commits the crime of kidnapping if they confide another under their control, do so knowingly, and the person acts for the purpose to, and then we include each of the 4 scenarios in subsections A through D. We would suggest that only those scenarios which contain some support in the evidence would be appropriate to give. We included them all here just for completeness. any supporting evidence that the defendant reasonably and actually believed that Ms. Naffziger was committing a kidnapping by confining Elwyn to avoid apprehension by a law enforcement official, because we don't believe it's appropriate to include that. That Ms. Naffziger was confining Elwyn to terrorize anyone, or that Ms. Naffziger was confining, or that Mr. Duren believed Ms. Naffziger was confining Elwyn to commit an offense against Elwyn. So, really the only one of those four scenarios that we believe would be appropriately included would be the first one, to hold the person confined for ransom or as a hostage. That's the argument that the defense has been making. So we believe that that one would have some support, and that is the only one of those four scenarios that should be included. And again, with regard to statutory interpretation, the state submitted a pleading with multiple citations regarding statutory interpretation as well. There's opposition that it is appropriate to define kidnapping in this scenario.
And so once again, Attorney Spicer, with respect to McDonald, 163, 115, the statutory interpretation of defense of others includes the phrase forcible sex offense, which there's discussion in McDonald that it's not coextensive with aggravated felonious sexual assault in McDonald. Would you agree with me relative to that? So even though the McDonald says use the regular phrase forcible sex offense without getting into defining it, the state's position is that that's okay with forcible sex offense, but it's not okay with kidnapping?
I agree, because there's no crime of forcible sex offenses. This is going back to Davidson, where we're talking about an unlawful taking, and it's okay to have unlawful taking, and that is not a reference to a statutory definition, but it includes more than one potential crime. Here, there's a reference to kidnapping, which is statutorily defined. It is not a broader category of crimes. The parallel here would be if the language was not kidnapping, but interference with freedom. And that's not what the language says.
And am I also correct that the state's position is that once you answer the question that you just asked relative to the forcible sex offense versus aggravated felonious sexual assault, once you get past the McDonald question, and once you say that we need to define kidnapping, the state's position is also that the legislature hath spoken relative to defining kidnapping to also include what kidnapping is not.
Yes, and I think we're talking specifically in the context of kidnapping for purposes of justification of deadly force, where I think the context of that is very important, and then the interplay between 633.1, 633.1-A, and interference with custody, 633.4, indicates that whatever kidnapping is, we know what kidnapping is not, and Ms. Naffziger legally could not kidnap her own child for behavior consistent with interference with custody. And there is a great risk that, based on the testimony and the evidence, that the jury may act on a mistaken belief of the law that that is what kidnapping is. And we want the jury to understand what kidnapping is and what it is not.
Attorney Spicer, I haven't made my mind up yet as it relates to this issue, okay? So my next question for you is, if all that's true, am I invading the province of the jury as it relates to giving this specific instruction as it relates to the elements of the general offense? Am I impermissibly, does that instruction that you're asking me to give, does that impermissibly invade the province of the jury? And or does it essentially does it mandate a specific outcome which is impermissible under the law?
No, I think the court would be simply, defining the boundaries here, and then the jury is free to make its own decision about whether things fall on one side or the other. The court is not instructing as to any of the elements or whether or not the evidence has satisfied them in favor of the state or otherwise. The court would simply be giving a definition of what kidnapping is.
Okay, thank you.
The way the legislature has written the statute, the only guidance that the court can give is the word kidnapping or about to commit a kidnapping. That's what the legislature has said. The legislature has explicitly omitted an interplay between 627.4 and 633.1 or 633.1A. The legislature knows how to connect those statutes, and it chose not to. And the court cannot ignore that deliberate choice of the legislature. The jury should be instructed on what the statute says, and then from there, it gets to use its own interpretation of what kidnapping is. I'll note without, that is our position, I think that's the correct reading of the statute, but some additional issues with the state's proposed definition is that the final paragraph creates a risk that the jury will believe that Ms. Naffziger could not kidnap her own child, full stop. And that's incorrect as a matter of law. And then also I do think that evidence has been presented that Ms. Naffziger acted with the purpose to terrorize Mr. Duren through her actions. So again, the court cannot create an interplay that the legislature does not say exists. The court cannot instruct on the definition that the legislature has not given in 627-4.
And for the record, again, legally as opposed to factually, that's why I issued the order I did a couple Fridays ago asking for instructions. I know council already knows that, but I knew we were gonna get to this point. I didn't know, I take that back. I didn't know we were gonna get to this point. My assumption was we were gonna get to this point where we are right now, and I wanted to make sure that we had adequately briefed the issue. And I know council has competently and with great care, council has competently briefed the issue relative to both sides. So that is why I wanted to focus everyone on what I did a couple weeks ago, which is why we're here right now. Okay, anything further, Attorney Spicer?
No.
Attorney Kettles, anything further?
No, Your Honor.
Okay, all right. So once again, I'm going to make my mind up. I'm going to take a brief recess. I'm also going back to the, I'll make a final decision. We're all set on reckless conduct with a deadly weapon. I'll make a final decision as it relates to child endangerment. And I'm going to check one thing, and I'll make a decision as it relates to this specific issue. And again, I haven't decided what to do, but Attorney Kettles, if I grant the state's request, it's hostage and terrorize?
Yes, Judge.
Okay. All right. All right. We're getting there, counsel.
Okay, all rise.
And I'll get the verdict form disseminated right now, also during this break. Be back when I can. Thank you.
County Superior Court is in recess.
Once again, for those uninitiated in this process, the reason this takes so long is because we need to make sure that we have all the evidence in, number one. And number two, the reason we're doing this is to make sure that council can adjust their closing arguments based upon how they know that I'm going to be instructing the jury, which happens after the closing arguments are conveyed to the jury. So I think the final issues before the court that needs to make a decision on with respect to the endangering the welfare of a child count, I'm going to maintain the version which is included in the draft that was circulated, with the exception of removing the court making a finding relative to duty and inserting a element relative to the need for the state to disprove that element beyond a reasonable doubt. Excuse me, the fact that the defendant did not act in defense of another, that the defendant acted in defense of another. I'll add that element as a fifth element. I'm taking out the recitation to the court making a finding relative to duty. Relative to the legal issue relative to definition of kidnapping, I thank the state with respect to its prompt ability to submit a document relative to the definition which is being advocated by the state. Let the record reflect I've gone back and reviewed State versus McDonald again, 163, New Hampshire 115, relative to an analogous, not necessarily on point because it's a different nature of the defense, but to an analogous situation, and I'm going to grant the defendant's request relative to not providing a specific definition as requested by Attorney Kettles. I reviewed the state's request again. Again, I reviewed State versus McDonald, and brief shepherdizing relative to running that case forward for any negative authority on the applicable point. I did not see any, so as a result, I am going to grant the defendant's request relative to leaving the term undefined or using a non-statutory defined meaning. Am I correct, by the way, you're advocating, Attorney Kettles?
Yes, Judge, meaning undefined.
Okay. I've also circulated the proposed special jury verdict form. Any comments with respect to the verdict form?
Your Honor, the only comment I have is a suggestion that perhaps with regard to the two murder charges, it might be helpful to include knowing or reckless, just so that there's no confusion on which charge they're
Okay, anything else?
considered. No.
In addition to that suggestion, Your Honor, we would prefer that not guilty be first and then guilty.
Okay, any objection relative to including knowing and reckless relative to parentheses? And switch not guilty and guilty?
Yes.
Any objection on that?
No.
Okay, court will grant that request and will interpose or will flip around the guilty and not guilty relative to that. Anything further, Attorney Kinney, on that?
No.
Okay, all right. Attorney Spicer, what have I forgotten?
I don't think anything.
Attorney Kettles, what have I forgotten? I know everybody, I know people have maintained their objections. Everybody's maintained their objections. Are you satisfied with your record, Attorney Spicer?
Yes.
Attorney Kettles, are you satisfied with your record?
Yes, Judge, the one thing I noticed, there's been a lot of discussion once I don't think that there will be, but once we review the final draft, if there is any concern, notwithstanding the objections we've already made, but I'll address it immediately, once I've seen it in writing.
Okay, so, just so I'm clear, nothing I've forgotten, and I mean, I'm gonna get to the next 12 hours procedure in just a second, but nothing else I've forgotten, and you're satisfied with your record at this point?
Yes.
Same thing?
Yes, sir.
Okay, so, what I will do in today's modern society is email addresses aren't that difficult to figure out. We already have everybody's email addresses. I will get this concluded. I'm not sure if it'll be concluded before 4:30, 5 o'clock. I'll get it concluded and get it emailed to folks. My only order, and I'm gonna be emailing it directly to all four counsel. The only thing I'm gonna say is do not email me back. Do not email me back because I'm going to decline to respond. If there is an issue, if there's a typo issue, I encourage counsel to email each other and leave me out of it. If there is something, if any of my rulings are unclear, I hope they're not unclear, so you could prepare your closing arguments. But if there is a drastic issue which needs to be addressed, we will address it before closing arguments tomorrow. We'll get that fixed, but hopefully I've provided enough instructions right now relative to my rulings so that you can prepare for closings. I will email directly because my excellent monitor will be, I'm not going to get it done in the next half hour, but I want to take the time that it needs, that it deserves under the circumstances, under this important case, and very good lawyering by both parties relative to the issues at hand. Clerk Restaurants, anything I'm forgetting from your perspective? Okay.
Do you want to ask them back at 8:45 tomorrow, just so we can see if
Can
they're?
we, 8:45, just to be safe? 8:45, in other words, I'll be ready at 8:45 if we do have to address anything. If there is nothing to address, then we can proceed right to closings at 9 o'clock. Okay? Okay? Okay, all right. All right, thank you for your work today, and that's why we didn't hold the jury, and we'll see everybody at 8:45 tomorrow. Thank you.
All right.